electronics. 12 and 13 are the ones I want for present purposes. I'm just showing you the description of how section 31, 1 and 2 work. If I could just invite you to read 12 and 13 to yourselves, if you would.
Sorry, Sir James. The page again.
Page 914, my lord, I'm sorry.
Thank you.
And it's paragraphs 12 and 13 when you get there. So as you see from that description, there is a distinction between 31.1 and 31.2. As the Supreme Court stated, or at least implied, based on the different language that is used between those two provisions. If the presiding officer decides that a draft bill is, or a bill is not within competence, the consequences are as described in paragraph 13. In other words, it wouldn't prevent the bill from being introduced, but it would be an important signal, as the Supreme Court put it, to the Scottish Parliament and the law officers considering a reference. However, a person in charge of the bill, if you go back to page 134 in the electronics, you'll have the text of section 31 itself. And you can see that the opening words of 31.1 were the subject of an amendment, as footnote 2 indicates, in 2012, so that it now covers both executive bills, if one can put it that way, bills presented by the Scottish Government, and it covers private members' bills, or the equivalent.
So what did it say before?
I think it said something like a member of the Scottish Executive.
Oh, right, okay.
But that's the nature of that change. But on the contrast, if a person in charge of the bill understood in that way is required on or before introduction, they're now required to state a positive. They've got to state that in their view, the provisions of the bill would be underlined within the legislative competence of the Scottish Parliament. And if they can't do that, they can't comply with the statutory duty. And our submission, which we understand to be common ground between the parties on this reference, the person in charge of the bill can't introduce it. They would effectively be inviting the Parliament to legislate on what they regard as an unlawful basis.
But the Lord Advocate has no role in it.
She doesn't. Under the statute, my lady, you're right, she doesn't. And I think the point was made by the President yesterday that maybe that both parties have put undue emphasis on the ministerial code, where what you're actually looking at is a statutory scheme. I mean, for the purposes of my argument, that doesn't matter terribly, but my lady is right. The Lord Advocate doesn't have functions under section 31. The functions that she has arise as a result of the ministerial code, and are not, as it were, imported into 31.
You say that if the statement isn't made, the person in charge of a bill would be inviting the Parliament to legislate on an unlawful basis, but isn't there a middle position where they just don't know because of uncertainty?
My Lord, my respectful submission is that that's difficult under the structure of this provision, because they're required to state a positive.
Well, precisely, that's what I'm putting to you. If they can't state a positive, you said, well, that shows that it's, they believe it to be outside competence. But they may be in a position, indeed I think the Lord Advocate says she's in the position, where in view of all the material, background materials and arguments about the law, they just can't be sufficiently sure to state positively in the form of section 31.1.
My Lord, my submission is that this is a binary question. On its true interpretation, this is a binary question, and that indeed, as we understand it, is how it is approached by the law officers in Scotland. And so there could be a debate in theory. My Lord will be very well aware of the debate that rages within government as to whether or not you have a 51-49% standard, or you have a respectable argument or a stateable case standard. My understanding, at least from academic articles that are included in here and from the runes, so far as one can read them from the Lord Advocate, is that the standard that is applied is a balance of probability standard, a bit like the current government practice, at least in relation to the HRA, when they make a statement under section 19(1)A. And so my submission is that what this requires does not leave open to the person in charge of the bill the option of saying, I'm a bit doubtful. They either can state the view or they can't.
Yes, I appreciate this doesn't leave open that option. They can't say, well, I'm a bit doubtful, but let's try it anyway.
But your point is they wouldn't necessarily be inviting the Scottish Parliament to legislate on an unlawful basis because they may not be...
Yes, I mean, as I understand it, almost the thrust of the case against you on this is there may be a good, indeed it is said there is a good arguable case that such a measure would be within competence, but because of the uncertainty about that, the law officer, and I assume the minister acting on their behalf, conscientiously feels they can't make the positive statement required in section 31(1), but then it may still be the case that in truth, if the matter were determined, this would be within competence. And the effect of this position is that because they can't state positively their view, even though they may believe that there's a good arguable case for it, that good arguable case is never tested.
Yes. And my submission is that that's the way in which the Act is set up. The Act is set up in a way that requires, as a precondition under the statutory scheme, the positive statement from the law officer. It doesn't allow for the position in which the bill can be introduced, even in circumstances where the law officer is not able to make that positive statement and thereby to comply with the duty that's imposed under section 31(1).
But if the Lord Advocate is able, under paragraph 34 of Schedule 6, to bring a reference to test that very issue, then in light of this court's ruling one way or the other, it may be possible for a positive statement then to be made under section 31(1).
It may be, and that's the debate. But that's the debate that you're having to resolve. Ultimately, that's the interpretive debate. Does the Act allow for that possibility under paragraph 34? And that turns fundamentally on the reasoning, on the proper and true interpretation of the tailpiece wording in paragraph 1F of Schedule 6, or is the position that ultimately the structure of the Act doesn't allow for that, and that this provision, 31(1), requires a statement to be made, and if it can't be made, then the bill can't be introduced and the position will not be tested. I quite understand the case against me says, well, legality suggests that it would be better if the court were allowed to test that in a case where there was doubt in the mind of the law officer or of the person in charge of the bill.
Yeah.
My submission ultimately is you can't get there because that does too much damage to the structure of the Act. But my Lord is right, ultimately that's the issue between the parties.
Yeah, I mean, I just wanted to press you on this, which may be important. I mean, you make the point about legality, which is one of the points made against you, but isn't there if you like, a democratic argument as well, that it may be that truthfully, as properly construed authoritatively by a court, there is competence. Yet, because of the context in which they're operating, a minister and the Lord Advocate at the moment feel that they can't make the positive statement in section 31(1), and so the bill can't be introduced. And so it might be said, in order for the democratic authority of the Parliament to be engaged, where they do have competence, I'm not indicating any view on the merits here, but just in principle there may be competence. One might expect that not just the principle of legality, but also the principle of democracy would suggest that paragraph 34 should be read sufficiently widely to allow this sort of application.
Well, my Lord, you've already had my response at least to a part of that question, which is, so be it, this is the structure of the Act. My answer directly to the democratic way of putting the legality point is that you can see, and this will depend on the strength or otherwise of the submissions I'm about to make on the true construction of 1F and how it all hangs together in toto. But if the position is that on the true construction of this Act, you can't get to that place, then that provides you with the answer to the democratic question, because Parliament has decided on a true interpretation which is for the courts, of course, but Parliament will then have decided that if a person in charge of the bill is not even able to say to the requisite standard, assume it's 51%, that the bill will be within competence, then a bill simply can't be introduced. And the justification for that in policy terms, if one's looking at it from that perspective, legislative policy terms, is that Parliament has decided that if that hurdle cannot be surmounted, then the court shouldn't be troubled with those issues, and that's an integral part of the structure. But I fully accept that that depends upon all the other indicators to interpretation that are going to bear on, in particular, the question whether those words in the tailpiece of 1F can work in the way that my learned friend needs them to, so as to tee up a 34 reference to get you, the courts, into that question.
Yeah, thank you.
And, you know, I've been thinking about, just as an illustration, the animal defenders case, where the minister introducing legislation in the UK Parliament providing for a ban on political advertising did not feel able to make a Section 19 statement that the bill was compatible with convention rights.
Yes. And it went off to Strasbourg, and
The issue eventually went to Strasbourg and was decided, I think, 9-8
yes,
in favour of the compatibility of the legislation.
my lord, yes.
What might be thought to be anomalous about Section 31 on your interpretation of it is that the final arbiter of the competence of the Parliament
Is the person in charge of the bill and not the courts,
exactly.
so as to exclude the animal defender's possibility.
Yes.
My lord, I take the point. It's another way of expressing the same thought that I suspect my Lord Sales was putting to me.
Yes.
And my answer to the direct point my lord puts to me under the HRA is that the structure of Section 19(1)(a), to which you will need no introduction, is rather different to this. And so the question whether you end up with that anomaly, if that's the right way of looking at it, is ultimately still a question of statutory interpretation. And under the HRA and Section 19, that scheme is very deliberately set up in that way, because as you will recall, A is yes, B is no, but on either event they can put it to the House. They just have to put it to the House with their feet to the fire in terms of compatibility if the answer is no. So that's absolutely squarely built into and clear from the structure and the relevant provision in the HRA. So I think that's my direct answer to my Lord's point about the animal defenders litigation. But of course, my Lord is right that it tees up the broader question that my Lord Sales was.
But doesn't that question arise anyway, because compatibility with the convention is also, isn't that also something that the person in charge has to be
They do under
satisfied
29(2)(c).
about? But that's not something that the Lord Advocate says can be referred to the court because it's not a reserved matter. So
Yes.
even on the Lord Advocate's case, I think that anomaly might still...
It will, and that's going to be central, you won't be surprised to hear me say, when we come to 1F and working out what the meaning of that is and how it coheres with the structure of the Act, which is ultimately going to be determinative of the issues that we're now discussing, which is whether or not 31(1) is to be construed in the way I suggest or not. That is going to be a pretty important point. But can I develop that when I get to that bit of
Yes,
it? Maybe more
and
logical to do it
could
now.
I also flag up that in your answers to my Lord Sales and Lord Reid, you slightly elided the Lord Advocate's inability to come to a view with the person in charge's inability to come to a view. And that's an aspect that concerns me as to whether there's an oddity with the Lord Advocate being able to make a reference if the bill is being introduced by a minister, which then confers on her the role on which she seems in some respects to be relying, but that role doesn't arise
If it's a person in charge of a bill or the minister.
Yes.
Yeah. Well, my lady, I think in answer to that, I think the only thing I would I would say, which I know you're very well aware of already, is the point I made earlier, which is that this has got to be the view of the person in charge of the bill, and the ministerial, the Lord Advocate's role in relation to that is, as it were, behind the scenes in relation to a relatively narrow category of case, and might well give rise to at least the oddities that my lady draws attention to.
I'm not sure that's such a problem, is it? I mean, if a minister was in a state of uncertainty, and I think you're right to focus on the words of section 31.1, which points to the state of mind of the minister in this case rather than the Lord Advocate.
You'd still have the same drama.
You still have the same problem, and then it would be open to them to go to the Lord Advocate and say, I think it's arguable, I would have difficulty conscientiously saying positively that that's the position, that it ought to be tested. Please, can you now, if it's available to you, operate the mechanism under paragraph? The
same issue would arise.
Same issue, yeah.
I fully accept that, and indeed you can posit myriad different hypotheticals. They don't like the view of the Lord Advocate, they feel able to disagree with the view of the Lord Advocate, or they decide they don't like the view of the Lord Advocate, so they're going to go to someone else and get a second opinion on the particularly fraught issue, all of those. But I entirely accept it doesn't terribly matter how you get there. The problem to which the issue of interpretation ultimately gives rise arises whenever you have a situation where the person in charge of the bill is doubtful about competence.
The points you just made about them seeking advice from other people, almost talking it around until they find someone prepared to give them the right advice and then making the statement. I mean, doesn't that, if you like, underline the importance of having a mechanism in an appropriate case of coming to a court to get an authoritative ruling on that very point, rather than just leaving it to the vagaries of what the minister might think and who might be prepared to give them legal advice that they want to hear?
Well, my lord, if you took a cynical view of that process, then that may well be a fair point. I was looking at it from a slightly different perspective, which says you can legitimately go and test a view, and the view of one law officer may not necessarily coincide with the view of someone else. So, but
I'm pressing on this because
you are, because you want an authoritative view from a court.
Yes, absolutely. I mean, it's such a fundamental point.
Yeah.
It might be said that it seems a bit strange that you can't get an authoritative view of a court on that issue, and it all depends upon what the minister happens to think or who he can find to advise him.
My lord, I accept that there is, of course I accept, that there is that point lurking, as it were, against my submission, because my submission has to be, and is, so be it, in relation to 31.1. The question is there a sensible, proper interpretive route that leads to that outcome? Or is the position that Parliament has been big and bold, as it were, in relation to this particular bit of the structure? And my submission is that that's exactly what they've done, and you can see that because the myriad difficulties that exist with trying to interpret the tailpiece words in 1F to do the job that my learned friend needs them to do to get you that outcome. Yeah. But I'm not shying away from the attraction, and of course one sees it forensically, particularly in this court, of a point that says otherwise you're not going to get an authoritative view from a court, you're going to get in effect a final view from an executive person that might be doubtful. Of course I accept that that's a question that needs to be grappled with, but that's why we're in the interpretive game we're in. Yeah. That's why we're going to the points that I'm going to go to. So I hope that doesn't shy too far away from the point Rob was putting away. So, I was on section 31.1 and I'd explained or sought to explain how the thing works and that difference or distinction between 1 and 2. 1 throws up the issue, 2 really doesn't, because it's just a view and then people can decide what they want to do about it, law officers referring or Scottish MPs voting in relation to the bill. But I do submit that that structure, particularly on our conception of it, 31.1, is an important part of what the court described as the pre-legislative safeguards that exist in this bill, and the expression of a view, the ability of the law officer or the person in charge of the bill, I'm not going to keep eliding those, the person in charge of the bill, the ability of the person in charge of the bill on advice or not to make the positive statement is an important part of the safeguard. And my submission ultimately is that the existence of 31.1, and we've rather explored this, does not enable through section Schedule 6, paragraph 1F, the person in charge of the bill or anyone else, to bypass, because that's what would happen, in effect, the careful structural preconditions and temporal preconditions to a reference in relation to draft bills or past bills that are set out in the Act that I took you through yesterday. And I wanted to make 5 initial points before coming directly to the true interpretation of the tailpiece wording in paragraph 1F, if I may. So 5 initial points, if I may, on that. Firstly, the Act recognises the starting point that I went to yesterday, that courts don't normally rule on inchoate pieces of legislation or ideas for legislation, and there are powerful reasons of principle for that starting point, and then deliberately sets out a careful regime, all of which is plainly designed to get a bill before it gets to this House, to this court, designed to get a bill to a state of finality immediately prior to consent, or assent. I went through all of that detail yesterday, and I don't repeat the detail of it. We submit it's entirely consistent with the structure and terms of the Act to interpret 1F in a way that does not allow that to be undermined or bypassed. And on that basis, 31(1) is a precondition, and as such is simply a part of the pre-enactment safeguards that Parliament has seen fit to put in place. That's the first point. Second point is that the United Kingdom Parliament were evidently concerned to ensure, in section 31, that the responsible people, i.e. the people in charge of the bill, consider and pin their colours to the public mast on competence. It is for the person in charge of the draft bill to form that view. It's their responsibility, legal and political as it were, under the scheme of the legislation. And it isn't, we submit, a responsibility under the scheme of this Act which is simply to be farmed out to the Supreme Court with an invitation for them in effect to provide advice to the person in charge of the bill and or the law officer. Thirdly, the logic of the Lord Advocate's position as to the meaning and effect of 31(1) and the related issue of the meaning and effect of paragraph 1F in its tailpiece wording is, we submit, uncontrolled and surprising. If 1F in its tailpiece wording does allow for the self-same issue to be referred, i.e. the self-same issue that could be referred under section 33 as a reference once the bill had reached finality, if that's the position, truly, where is the limit on her case? Suppose the Scottish Government have an early draft of a bill. Suppose the Scottish Government are thinking about introducing a bill that might be in something like this form. What if there isn't a bill at all, and they simply have an abstract legislative policy idea? At what stage of formulation of that abstract legislative policy idea does the 1F wording cut in to allow the paragraph 34 reference? How developed does it have to be? And of course that's a critically relevant question because of the very structure that leads to the section 33 reference designed to ensure finality of bill before court ruling. And you will note in that respect the enforced pause in section 32(2) of the Act on page 137, the presiding officer cannot submit for assent a bill which has been referred under section 33. That doesn't apply to a paragraph 34 reference on the Lord Advocate's case. So if shortly after this reference a backbench MSP felt able to introduce the bill because he was marginally less squeamish about the idea of competence than the Lord Advocate entirely properly is, it could be debated and passed whilst all the while this reference under paragraph 34 is going on. one can multiply the questions. If paragraph 1F allows for the self-same issue to be referred at any stage, is it said, and this was the subject of some probing questions yesterday, is it said that that would be allowed or permissible even after introduction, but before passing? And of course the sting in that particular tale is that after introduction you're even more squarely within the legislative processes that lead up to the paragraph, to the section 33 reference. But is that possible? And the Lord Advocate yesterday took what we submit to be the surprising stance that it could apply a paragraph 34 reference even during the course of its passage through the Scottish Parliament. And we say you couldn't have a starker indication than that as to the extent to which her argument therefore undermines the careful delineated process that leads to a section 33 reference.
But, I mean, so far as that is concerned, I mean, there is another control mechanism, which is the discretion of this court whether to entertain a reference.
That's going to be my fifth point. Is it adequately controlled by the Lord Advocate's discretion and or the Supreme Court's discretion? Can I come to that in sequence?
Your point is that if it's right that a paragraph 34 reference can be made even after the bill has been introduced, then 32(2) doesn't seem to preclude it getting royal assent whilst the matter is pending before this court.
Yes, and that preclusion, that preclusion doesn't cut in the same way. And there's a broader point, which is look at the trouble that Parliament went to describe what has to have happened, including through the standing orders process and all the bits I took you to yesterday under 36(1). Look at those detailed processes, they all get swept away. And you've got to answer the question in principle, well, where is the control? At what point, before or after introduction, the same essential problem arises, which is that you've got to grapple with what the principal distinctions are. After introduction, it's a slightly different one, because you're obviously cutting across the processes that Parliament has laid down. If you do it before introduction, you've actually got to grapple, in my submission, with the question, when principally does that stop? When, as a matter of principle, does it stop the 34 power on the Lord Advocate's case? And of course, on their logic, if 34 works, you could simply refer the matter even if it was a pretty hopeless argument on competence. But there's a kind of merits point there. Now again, my Lord Salisbury may say to me, well, that can be controlled by the discretion of the court. If it's ultimately and obviously hopeless, then we'll step in and fix it.
If a backbench MSP introduced a bill and was debated and passed, whilst a reference was going on, surely in practical terms, the Lord Advocate would then trigger the delaying mechanism under the legislation by making another reference in relation to the act as the bill as passed.
Possibly, possibly not. And it would depend upon the timing. But one's got to make it work. There may be tools there that might mitigate some of the worst excesses of this, but it's difficult to see how it sits coherently and squarely and faithfully with the scheme of the legislation that Parliament has set up, I submit.
But where a reference is made under paragraph 1A of an act, then presumably the act continues in force and in operation pending this court's decision.
It does. And we place reliance on that when we get to Schedule 6, paragraph 1, because there's a specific reference to enacted legislation. Again, not to multiply the questions absurdly, but one could, on their logic, be referred, even if there's no bill at all, not even a proposal to legislate in a particular way. And that would drift towards setting, as it were, entirely hypothetical questions into the lap of this court under paragraph 34, inviting them to rule on legislative policy. And again, I come back to it. Part of the constitutional difficulty with that, unless you can find a clear distinction and line and cut-off point, is that it does risk, as it were, dragging the court into the political process, which the structures that the Act sets up are assiduous to avoid, because all of the democratic processes have already happened. The only thing that remains is the King's chop on the piece of legislation that has otherwise gone through the democratic processes and been passed. That's the democratic attraction of that structure. And so one does need to be wary, or at least to balance against the democratic points that my Lord Sells was putting to me. One needs to balance that democratic feature, which is inherent in the very structures of the Act. But one also notes finally, and I promise this is the last point on this particular contentious way of putting the argument, but one notes on the logic of the Lord Advocate's case, it would be open, perhaps surprisingly open, to the other law officers, the law officers who are, as it were, representing the UK Westminster aspect of this. It would be open to the AGS or to the AG to refer at any and all of these early points in the development of legislative policy by the Scottish Government. That seems inherently unlikely as an intention to impute to the UK Parliament. It might be thought to be as unlikely an intention to impute to the UK Parliament as it would be unwelcome to the Scottish Government itself, were that truly to be the position. But why isn't that the logic of the Lord Advocate's case? And the only way in which the Lord Advocate seeks to escape from that no doubt unattractive consequence of her argument is to say, no, we don't need to worry about that because it's only the Lord Advocate who can refer under 34, because it's only the Lord Advocate who would have the function under section 31. But of course, that's a hopeless argument, because the function under 31 is not hers, it is the person in charge of the bill. So that can't possibly be right. But in any event, it doesn't matter whose function it is on her case. The question only is whether or not Schedule 6, paragraph 34 is triggered. And if it is triggered, because there is, for the sake of argument, doubt about competence under Section 31, the Section 31 statement is problematic, or you're at an earlier stage, then all of the law officers under 34 have the option, or none of them do. It can't depend upon the Lord Advocate being involved or engaged in the function under Section 31. So, for those reasons, we do submit, unaddressed, I would respectfully add, by the argument that is mounted by the Lord Advocate, for those reasons we do make as a third submission the point that the logic of her position is, as I put it earlier, uncontrolled and surprising. Fourthly, to touch on a point and I can take it very quickly because we've touched on it already, there is, we submit, no unacceptable democratic or legal lacuna. This isn't a situation in which something with legal effect has occurred, but whose legality could not otherwise be brought before a court. And for that reason, it's nothing like the Jackson case, which I think was relied on in the Lord Advocate's case. To the extent that it follows that this draft bill, or a draft bill like it, or legislative policy, if you're in the same position, would never be introduced or come to fruition, so be it, is our answer to that. There is no reason to suppose that the United Kingdom Parliament would have intended Schedule 6 to be used as a vehicle for that sort of issue in circumstances in which the person in charge of the bill was not, and I would say not even able to offer that positive statement on competence. And it is, we would note finally just on that point, it isn't as though the Lord Advocate in this case cannot answer the question in 31.1. The difficulty is that she can answer it and has done so. And the problem for her is that the Scottish Government do not like the answer that she has given on competence. She is not able to form a view with a sufficient degree of confidence that the bill which is proposed would be within competence. There isn't a difficulty with answering the question. The difficulty here is with the answer. That comes to the fifth point, which touches the point that my Lord Sells was raising with me a moment ago, which is all of this, or can all of this adequately be controlled by reference to either the Lord Advocate or presumably the other law officer's discretion in deciding when to make a reference to this court under paragraph 34 if she has that power, or the Supreme Court's discretion in controlling, for example, bills that are obviously outside competence and in relation to which there's really no acceptable issue. Of course, we recognise that there is something of a filter in paragraph 34 because the references can only be made by a law officer, and one would expect as a standard that law officers will behave in a responsible way, and that makes it to some degree less likely that the procedure would be misused. But our submission is that even if exercised in good faith, there is no reason why the United Kingdom Parliament would have intended to afford that power to the law officers to cut across the wider statutory scheme in the way that would be entailed. And we do note that the section 34, the paragraph 34 power has been used in the past in circumstances in which the Supreme Court thought that such a reference was inappropriate. You have in the opening segment of the authorities bundles the two Northern Ireland references, which you'll be very familiar with. They start at page 866. I don't invite you to turn them up now, but from 866 and then 874 onwards, you've got those two references. And the court did exercise that discretion. And so far as the Supreme Court discretion is concerned, my submission is that what one is truly seeking here is an answer from the terms and structure and nature and purpose of the Act. One is looking for the correct interpretation so as to divine Parliament's intention in relation to this particular legislative scheme. And of course, the Supreme Court will be concerned to ensure that any discretion which it had when it exercised it was being exercised in conformity and faithfully with that structure. We also note that although, of course, in those Northern Ireland references, the Supreme Court discovered that it had a discretion, and I don't for a moment cast any aspersions on the omnipotence of the Supreme Court to discover procedures or discretions that might assist it to avoid abuse of its procedures, nevertheless, there isn't an obvious Supreme Court discretion built in for this purpose or at all to the Act. So you've had to search for the source. I don't denigrate the search for the source is obviously there, but you've had to search for the source outside the four corners of the Act is the short point in relation to that. So although, of course, I accept that the Supreme Court has discretions to control particularly abuse of its own procedures, that only goes so far, I respectfully submit, in answering or assisting to answer the question what this structure with these provisions actually means. So with those five initial points...
Paragraph 34 follows on from paragraph 33.
Yep.
Which presumably must, I mean, devolution issue has to mean the same thing in both paragraphs.
Yep. The distinction between 33 and 34, as my lady sees,
yes,
is
that where the proceedings
exactly.
are not. Right, but I suppose the cases that you referred us to yesterday would suggest that it would not be possible in proceedings for an issue as to the legislative competence of an inchoate bill to be raised.
I think that would be
that would be
very difficult, because it'd be difficult to see what the law would be. Rather the point made by the Lord President in Keating that a draft bill has no legal status. And that's why these provisions, the section 33 reference procedure, is an exception to the general rule. So they've had to make these other provisions, including 33 and 34, which sit together in the way you've indicated. Can I turn then to Schedule 6, paragraph 1F? And I do so, of course, recognising the force of the point that I know the Lord President was interested in, which is when you just take the words as they sit, they look like big, broad words, particularly when you take into account the fact that arising by virtue of, or by virtue of, is a defined term under 126, as meaning by or under, I think, from memory. How far that adds to the interpretive sum is a more debatable question, but the words on their face look like big, broad words, so why wouldn't they work to give effect to legality and all the points that we were discussing a moment ago on that front. But we respectfully submit that despite their apparent breadth, they do need to be interpreted in the context of the scheme of legislation in which they sit. And I wanted to make 4 remaining submissions as to the true meaning and effect of those words. First, I state but do not repeat all of the points I've made earlier about cutting across the legislative scheme in relation to draft bills and the care which Parliament has set out in relation to that. It might also be noted that the Lord Advocate's interpretation of 1F also cuts across the provision in the scheme for who determines legislative competence before royal assent. If the question of legislative competence of a draft bill is a devolution issue under 1F, the law officers can institute proceedings for its determination under paragraph 4 of Schedule 6. Just see page 326, paragraph 4 of Schedule 6. There is no requirement or even provision in the Scotland Act for paragraph 4 proceedings to be instituted in the Supreme Court. Back to my Lord Reed's point about this is an original jurisdiction in the Supreme Court, and there's a constitutional reason for that in the Scotland Act. But if it's a devolution issue, why couldn't it be the subject of proceedings under paragraph 4 in ordinary proceedings, not to this court? And of course, law officers do have the power, which I was just discussing with my Lady Rose, they do have the power under paragraph 33, as it were, to divert such proceedings to the Supreme Court. But it doesn't require them to do so, and that would depend upon law officer discretion, which feels like a pretty odd consequence. The broader significance of this cut across point is that it renders it highly unlikely, we submit, that Parliament intended to undo all of those careful controls in relation to timing and draft bills and getting them to finality and all of that by general tailpiece words in Schedule 6, paragraph 1F.
If the Lord Advocate's reading of paragraph 1F is correct, then is the implication of paragraph 4 not that she could indeed have brought proceedings in the Court of Session
Yes.
seeking a declaratory order?
It is. That's my submission.
And why do you say there's a problem with that?
Well,
apart from your, why specifically about that? Is there a problem with that procedure?
there's no difficulty with a procedure that ends up in the Court of Session, which will give wonderful judgments as soon as it receives the issues. The problem that arises in relation to this Act, sorry to sound like harping on the same theme again and again, is that it makes specific provision for draft bill issues to come to this court directly.
Yes, I see. So it would obviate.
It would obviate. Well, it wouldn't entirely obviate it.
33.
I don't want to overstate it because paragraph 33 allows the diversion, but it's a discretionary diversion rather than a mandatory reference process per section 33. Yeah. That's the short and small point. And I mean, the difficulty is that the more you multiply all of these issues and these processes, the more force there would appear to be in the view offered by the Lord President in Keating's, particularly at paragraph 61, that if essentially the argument that my learned friend the Lord Advocate is running is right, that would be, as he put it, a recipe for chaos, rendering the careful structures under the 1998 Act redundant. That's the first point.
You say Keating's was wrong in if paragraph 4 does entitle the Lord Advocate to refer this devolution issue to the Court of Session, where does that leave the decision in Keating's?
My Lady, the answer is it doesn't undermine the decision, because the decision was ultimately taken and rested upon the application of the standard principles that I went through at the outset about academic appeals, and there were too many imponderables, thought the Lord President, to be dealing with that issue now. But my lady, in fairness, is right to this degree, that if my learned friend, the Lord Advocate, is right, why wouldn't it be said, or why shouldn't it be said? Well, there's the kind of paragraph 4 thing. It wasn't necessarily the Lord Advocate who brought it on a reference, but you could get to that same place, and then she would say it's not an academic issue at all, because what paragraph 34 envisages, back to my incoherences argument, is that you can refer a legislative policy idea that has just clicked into the head of the First Minister if it bears on competence and you're doubtful about what the answer is. So there is an oddity there, I respectfully submit. Anyway, that's the first point, the cutting across point. I don't seek to labour it any further. The second point is that if the Lord Advocate's position had been the intention of the United Kingdom Parliament in making the Scotland Act 1998, in other words, the setting up of alternatives at the choice of, for example, the Scottish Government, one would expect, I respectfully submit, one would expect to see that intention very clearly expressed in Schedule 6, paragraph 1. Not merely would you expect clear words to give effect to that because of the cut-across point, but you would expect Parliament to grapple with how this sort of reference might work with and relate to the processes that are specifically directed at draft bills under Section 33. So you expect Parliament legislatively to grapple with that interface. And it might be thought that it's all the more surprising that this is designed as a tailpiece set of wording to cover draft bills and legislative policy ideas in circumstances in which, if you go to page 322, so you have paragraph 1 before you, and it's a point that you've already picked up on, I know, but in a slightly different context, it's all the more surprising, we submit, given that the paragraph 1 at sub A does in fact deal with legislation, not with draft legislation, but with legislation itself. If it's going to deal with the legislation itself, why doesn't it deal with draft bills, particularly given that Section 33 contains all of the processes and 36(1) sets out the democratic processes that have to be gone through before you get to a stage of a 33 reference. All the more surprising, we submit, therefore, given that legislation as a concept is covered in 1, that this is not dealt with clearly and specifically. Whereas, of course, given that 1A does deal with enacted legislation, that sits entirely coherently with a scheme that is designed to set detailed pre-enactment safeguards and reference procedures in relation to draft bills. There's nothing problematic with that. What this is doing is making provision for reference of devolution issues in circumstances where the Act has already become law and continues to have legal effect. Moreover, it's intensely surprising for a slightly different reason that it isn't dealt with specifically if the Lord Advocate is right, because there is nothing at all in paragraph 1 about bills or inchoate legislative proposals, depending upon how far the logic of the Lord Advocate extends. There's nothing in there at all, despite the fact that proposed things, if I can put it generally, are indeed dealt with as proposed things in paragraph 1. See, for example, sub B, a function which a person has purported to or is proposing to exercise. C, proposed exercise of function. D, proposed exercise of function. So why not proposed legislation? So they're covering all the subject matter, but they're not covering this. So you have to assume that the parliamentary draftsman is in effect ignoring the elephant in the room. That's the second point. The third point is perhaps a bull point, I respectfully submit. The Lord Advocate's interpretation of those tailpiece words we submit does not make sense in the structure of this Act. There is a substantive aspect to that submission. Their case is effectively that the Section 31(1) inability of the person in charge of the bill to make a statement, a positive statement of the kind envisaged by that section, gives rise to take the wording of 1F at the tailpiece, a question arising by virtue of the Act about reserved matters. And they say it's important that that should be able to be referred under paragraph 34, because otherwise competence issues preventing the introduction of legislation with all of the democratic and legality issues to which my Lord Sales referred would arise. That's the case. The difficulty with that case, as a substantive proposition, is that the tailpiece refers and refers only to reserved matters. And that does not square with this core purpose for which the wording is said by the Lord Advocate to exist. There could be, to put the point in a slightly different way, precisely the same inability or doubt about whether that statement could be made as a result of any of the grounds that are set out in section 29 sub 2. Page 129. The person in charge of the bill could be unable to make that statement or doubtful about that statement because, for example, they were doubtful about whether or not the draft legislation would be or would not be incompatible with ECHR rights or would be a breach of restrictions under Schedule 4. Yet on her case, they couldn't refer in reliance on paragraph 34 because paragraph 34 is restricted to reserved matters. And my learned friend, the Lord Advocate, was tellingly unable, in answer to the direct question posed by Lord Sales yesterday, to which he promised to return but didn't, to provide any reason why, if she is right on the interpretation of paragraph 1F, Parliament would or might have chosen to draw that distinction. It cannot be said that there might be an explanation for that because reserved matters are more fundamental, which is, I think, a prospect possibly floated by Lord Sales saying, well, I thought you might be saying that. That can't be the position because there is no hierarchy in 29.2 of importance. And that inability to answer that question in any sensible or coherent form, we respectfully submit, is nigh on fatal to the suggestion that the wording was designed to cover what she needs it to cover. What this indicates is that Parliament cannot have intended that set of wording to be a catch-all picking up within the language of paragraph 1F doubts about a section 31(1) statement with all the preconditionality that that entails. If that had been the intention, put the submission in a sentence, if that had been the intention, why doesn't the tailpiece wording in 1F refer to competence? That's a substantive difficulty, and I will come as my fourth and final submission to the wording, back to the tailpiece wording, to say what we have to say positively about the explanation for why reserved matters and reserved matters only is referred to in that paragraph. But I just wanted to touch on a procedural incoherence, if the Lord Advocate is right, to go with the substantive one I've just described. And of course, this procedural incoherence arises only if one could get past a position in which the person in charge of the bill is unable to make the statement. But on that basis, if they were able to get past that, then competence issues that could or would be referred under section 33 could then include and do include broader questions going to competence. For example, the restriction in Schedule 4, paragraph 4.1 that the court considered in Continuity Bill and then in UNCRC about making modifications or not making modifications to various delineated or listed acts. Yet on the Lord Advocate's case, you would have to have two stages in such a case. One, to consider the reserved matters under 1F, and then, if the bill could still be passed, under a subsequent section 33 reference, raising other matters that do not fall within the concept of reserved matters but might fall within, for example, Schedule 4 or human rights, whatever it may be. And that is a procedural bifurcation oddity, to put it at its very lowest, with all the disadvantages of a split procedure, and no doubt that was another part of the Lord President's view about the recipe for chaos as expressed in Keating's. And again, I don't seek to and don't need to go as far as to say that there aren't some parts of that that couldn't be controlled by the exercise of judicious discretion by the court, but it isn't and can't be a complete answer to the issue of interpretation which is raised. That procedural oddity, and we would put it higher than that, but that procedural oddity, to put it at its lowest, is a serious substantive, procedural rather, incoherence in the Lord Advocate's case. So the fourth submission in relation to 1F and the tailpiece wording then is that they do have a straightforward and evident purpose, that is, referring to reserved matters only, without seeking to import the breadth and the controversy, if I can use that single word to incorporate all the earlier submissions, that the Lord Advocate's case entails, including the dissonance with the various careful structures under the Act. Our submission is that the evident and core purpose of paragraph 34 and paragraph 1F in the tailpiece wording is to permit references of groups of issues that might bear on legal provisions in the enacted legislation or public functions that plainly arise by virtue of the Act. The Lord Advocate mentioned yesterday that this tailpiece wording was inserted by amendment during the passage of the Scotland Bill, and she is right about that. We've looked back overnight at Hansard and have found little or no real assistance on the issues that you have to confront there. It was simply described as being one of a suite of technical amendments, as it was put, so not much assistance from that. But if I can go with a little temerity, as at least, if I can go to the explanatory notes that you have starting at page 365 in the bundle, I wanted to take you to one bit. I, of course, accept, I should interpolate to say, I, of course, accept that the explanatory notes of the Scotland Act were rather unusually produced in 2004, some years after its passage, so we're not in the usual contemporaneous document to which the United Kingdom Parliament would have had regard during the passage of the bill. That doesn't render them inadmissible for this purpose. It just gives them, as it were, reduced weight. This was the point considered by Lord Hope in Imperial Tobacco at paragraph 33, page 646. But it's quite sufficient for my purpose here, because I'm only drawing attention to the explanatory notes as a helpful collation of examples of when 1F in both of its parts might be used. So there's some assistance to be derived from it then. I should also add, sorry to interpolate some more, but I should also add that the document produced contemporaneously with the Scotland Bill when passing the Act of the Scottish Act, the Scotland Act, was called Notes on Clauses, and they are what one would normally call explanatory notes. And Lord Hope, of course, recognised the value of their interpretation in paragraph 33. We have placed a little weight on those notes of clauses in our case at paragraph 22 for a slightly different purpose, but the core point for present purposes is that those notes on clauses don't address the tailpiece wording in 1F and so aren't available to assist you as an interpretive tool for that purpose. I wanted, with that caveat and recognition of the caveat as to the status of these explanatory notes, to take you, if I may, to page 379 in the electronic bundle, which are the notes that deal with subparagraph F of paragraph 1 of Schedule 6. And you see that structure. The relevant paragraph for this purpose is the first full paragraph, perhaps the second full paragraph, sorry, or subparagraph, indented paragraph at the top of the page.
I'm wondering if you've given us the right page reference.
379?
This begins the Parliamentary Constituencies Act 1986.
Oh, maybe perhaps mine have got out of. Have I got out of kilter? 379.
I beg your pardon. I'm looking at the wrong bundle.
I'm sorry, my lord.
No, it's my fault.
So 379 should start with subparagraph E.
Yes, I'm with you now.
So drop down from E to F. That's the invitation. And you will see that the only example that's given, in effect, of something which deals with the tailpiece wording is really the last line and a bit of that subparagraph, or whether the functions of a body relate to a reserved matter, C1263, as an example of a question falling within the 1F tailpiece. Yes, of course. My learned friend Mr. Hickman has intervened at this stage. And the third line, which is to draw your attention to questions swept up in this subparagraph, can arise in various circumstances. Very happy to draw that to the court's attention. But I wanted to look at the example that is given there. 1263 you have on page 155. If you just flick back to that, you will see from that provision, page 155 in the electronics. Sorry to jump around a bit. Just wanted to show you the bit that's being referred to. It's in the interpretation section, sub 3. For the purposes of this Act, the question whether any function of a body, government department or office holder relates to a reserved matter is to be determined by reference to, and you'll see the familiar words and the familiar test for reserved matters, and so on. So that's it's when that sort of issue, that sort of test is going to be in play, is the example given. And the point is that there are provisions, and the core point perhaps is that there are provisions in the Act which would require the question that is posed by the tailpiece wording in 1F, i.e. whether the functions of a body relate to a reserved matter, or that example of it in the explanatory notes, to be asked. And they arise under the Act because the Act requires them, in terms, to be asked and answered in those terms. And they arise by virtue of the Act, therefore, in that sense. And there are various examples of provisions in the Scotland Act where the boundaries of reserved matters and what is and isn't a reserved matter might give rise to issues of law requiring resolution by a law officer reference.
One of the lessons of the case law on devolution is that because the categories listed in Schedule 5 are often expressed in very general terms, there can be real difficulty in deciding whether or not a particular activity or subject falls within a category or doesn't.
Yes.
And so questions about reserved matters, when we're just looking at those words, could very well include the sort of issue that the court had to decide in Imperial Tobacco, about how you classified a particular subject. I mean, is there any reason under the legislation why, if, for example, the Lord Advocate wanted to know, presumably for some practical reason, whether, say, a particular topic was reserved or not, why she shouldn't ask the court to decide that question?
There are examples, which I'm about to take you to, in the legislation where exactly that can be done.
Yeah. Now, the background might be she wants to know in order to give advice on a legislative proposal.
Well,
I mean, the likelihood is that would be why she wanted to know.
yeah, well, that's more difficult then, because then you run into all the submissions I previously made, and I don't repeat, about the basic structure of the Act and how draft bills are dealt with. My point at this stage is that there are provisions in the Act which require you to know, for the purpose of the exercise or the limit of a particular power that is specified, whether something does or doesn't relate to reserved matters.
Yeah.
And my submission is that it's to those things, rather than simply opening the can of worms, as it were, with all the crossover and the cut across that I've identified earlier. It's to those matters that these tailpiece words refer. And one can see that in the structure of the Act, there are provisions of that kind. My Lords, I was going to...
Well,
Yes,
if under Section 29 the Parliament can only legislate, if under Section 29 the Parliament generally cannot legislate in relation to reserved matters, and by virtue of Section 31 the Scottish Government can't introduce legislation which relates to reserved matters, then the question whether legislation relates to reserved matters is, I would have thought, a question arising by virtue of the Act. Now, she doesn't have to put a draft bill in front of a court, and this is, in the present case, is an extreme example, if you like, of a constitutional issue of the greatest significance. But there could be much more routine issues about, I don't know, restrictions on the sale of products, for example, where she might have a good reason for wanting to know. Does packaging of cigarettes, is packaging of cigarettes a reserved matter? Now, one could infer that if she's asking the question, it's probably because there's some consideration being given to legislating on the issue. But in terms of 1F, why shouldn't she ask that question?
Because, my Lord, the difficulty with that is that cuts across, I respectfully submit, the very careful and delineated structures of the Act that are designed to control that process. This is not a talking shop. This is not a jurisdiction created in this way by tailpiece wordings in paragraph 1F of Schedule 6. I mean, that would have enormous ramifications, not least constitutional, because the court is then being dragged at the behest of the law officers in all the devolved administrations into providing advice whenever they think a question is interesting, because they might or might not be doing legislation about it.
Well, that's one of the reasons why we declined to accept references in one of the Northern Irish cases.
My Lord, yes, but my submission is that when you're dealing with proposed legislation, the important fact is that Parliament has gone out of its way to specify how that gets done. And of course it leads to the position where if they can't make the statement, it doesn't get here, and I accept that, of course. But my submission is that that's an integral part of the Act. What you can't do is to construe those words in a way in which all of that gets thrown in the bin. They don't have to worry about any of that. They don't have to worry about putting it to Parliament, getting it sorted, getting it finalised, and then producing it to the court. They can simply go off with all the incoherences that only referring to reserved matters brings with it, if competence is the issue. Why do, I mean, my Lord has raised that point, but if that's right, why doesn't the reserved matters submission I made earlier cause difficulties for that line of thinking? Because, I mean, the Lord Advocate might be sitting there thinking, well, if I do the plain packaging on tobacco thing, that might be problematic in terms of reserved matters. It might also be problematic in terms of the HRA, because I'll be interfering with A1P1 rights, and I'm very worried about the fact that the proposed legislation I'm thinking about doesn't provide a right of compensation, and we might be taking away their intellectual property rights. So you still have to grapple with that incoherence. What all these provisions of the Act, I respectfully submit, indicate is that this isn't an uncontrolled scheme under which the Scottish Government can come and trouble this court with requests for advice, subject only to the court's discretion to refuse to do it. It sets up a jurisdictional set of structures and procedures which are specifically designed to ensure that when matters come to this court, this highest court, on a constitutional basis, they come with the bill in finalised form. And you can see exactly what's been done, those democratic processes have been gone through, or you have the devolution issue processes that you see set out in Schedule 6, but they're by and large to do with functions that exist or legislation that has been enacted. And so the question is there some meaning that can be ascribed to these tailpiece words, broad though they appear to be, which does not create that dissonance? And my respectful submission is that there is, because you can strew the words arising by virtue of the Act in a way that doesn't do damage to by or under, but simply says you've got to be able to identify the function, the specific time when reserved matters and reserved matters only are going to be interesting.
She can exercise the power in relation to delegated legislation, or even on your argument, I think.
She can exercise the paragraph 34 power.
Yes. I mean, so issues under in the
as it applies to reserved matters. See subsection 35(1)(b).
And that's at page what, sorry?
Page 144, my lord, sorry. So again, does it apply to reserved matters? That's in relation to a legislative function. And there's a similar power in 58(4), if you just go back to the little clip, in relation to subordinate legislation made or capable of revocation by Scottish ministers, if the same test as we've just seen in 35(1)b is met. In the Secretary of State's view, the Secretary of State can revoke the subordinate legislation himself. And you'll see that the limitation is in 4b. 58(4)b makes modifications to the law as it applies to reserved matters.
So these are all examples where Parliament has picked out from section 29
The reserved matters is using them to delimit or control the nature of a power. That's essentially
yes, and in which the other aspects of legislative competence would not be relevant in any event.
Wouldn't be relevant and aren't picked out for that purpose because they form no part of the controlling power provision. It's only in relation to reserved matters. 56(4), go back a page to page 4 of the little clip, where the general transfer of ministerial functions to Scottish ministers under 53 catches the power to establish, maintain or abolish a body which has functions which do not relate to reserved matters and also other functions which do. The power has to be exercised jointly by UK ministers and Scottish ministers. And you can see why in that circumstance clarification might be required from a court. Section 88 in this little clip, if you go forward to page 7, again, more complicated just as a context to work out what we're dealing with here, but it applies to, it's about cross-border public authorities, which are designated in orders, and it's got two relevant aspects. The first of them is in 88(2)b. The United Kingdom minister must consult the Scottish minister if it intends to exercise in relation to a cross-border public authority, a function which might affect Scotland otherwise than wholly in relation to reserved matters. Same idea. So the question is, does the consultation duty arise? And 88(6), which is similar to the power to compel witnesses, people to turn up and give evidence in the Scottish Parliament, but in this context, look at 88(6), such an order may only specify a body, government, department or office holder, which at the time when the order is made has, in addition to other functions, functions which are exercisable in as regards Scotland and do not relate to reserved matters. So it's essentially the same idea. And in relation to complaints of maladministration, over on the next page, page 8, 91 sub 3 sub D, any action concerning Scotland and not relating to reserved matters, which is taken by or on behalf of the cross-border authorities. So we submit that the references in the tailpiece wording is a reference to those sorts of provisions which specifically require reserved matters and reserved matters only as an idea to be considered. They're obviously important in the range of contexts, examples of which I've given. I'm sure there are others, but they're obviously important because the concept of whether something does or doesn't relate to reserved matters is specifically something which conditions the nature of the power or function, and so one can see why one would need a reference in some of those situations. But that interpretation of the tailpiece wording as referring to those sorts of things has the thoroughgoing virtue, we submit, of avoiding all of the substantive and procedural incoherences that I identified earlier, and avoids cutting across the careful scheme in relation to legislation of this kind, under section 31 to come to that specifically, as to when and how bills need to have reached a state of fruition, as it were, in advance of a reference being made under the proper process prescribed by the Act, namely that set out in section 3.
which of those examples falls within the second half of paragraph 1F as opposed to the first part of it?
Well, my Lord, my submission is that all of them do, because those are all questions arising by virtue of this Act about reserved matters. They're not the first part, which is, well, they may be included if you read devolved competence in that way, but they are all, as it were, tracking the wording of that tailpiece provision.
But
My answer is that they all do.
devolved competence is defined, I think, in section 54, which I don't think we have.
I'm sorry, we should have provided that as well. You might have to help Mr. Habits to find it. Well, can I see it? I don't want to start making submissions about a provision I haven't got in front of me. Can I see whether there's anything to be added on devolved competence in its definition?
It does seem to be relating to something different. I don't want to take time to read it out, but it might be, given that we are interested in whether there are things that are covered by the second half of 1F and not by the first half, the fact that the first half relates to devolved competence and the
as
second
a broader idea.
As a different idea. I don't know whether it's broader or not. It might be helpful to.
Can I now
Yes.
check that and come back?
It's a very broad expression, devolved competence.
Oh, I'm sorry, I missed that.
Effectively, it applies the limits that apply to the Scottish Parliament in enacting primary legislation to other bodies, such as the Scottish ministers, who also exercise devolved functions.
Yes, it's really sub 2, isn't it?
Yeah. Well, it's 3 is really the wider provision. The 2 deals with subordinate legislation, and 3 is all functions other than in relation to subordinate legislation.
Well, that's true. I wonder whether the significance of that, of either or both of those two provisions, 2 and 3, is that they effectively link the idea, as one might expect given the wording, of devolved competence to matters which would be outside the legislative competence of the Parliament.
Yeah.
But for the purpose of the exercise of functions of the executive rather than legislative functions.
Exactly so.
Yeah, but it has quite a major implication for your argument, because, essentially, insofar as functions are exercisable by Scottish ministers, they can be outside devolved competence. If the latter few words, put it this way, of your examples, I think, at a quick glance, it's only powers exercisable by the Secretary of State in relation to reserved matters, which would not fall within the first part of 1F, because the Secretary of State's powers are not limited by devolved competence.
But if there is a category which doesn't fall within that, then the point remains.
Yes.
There are other examples in the Act that show devolved competence or about reserved matters being used in that limited way that can't be brought within the first part,
Yes,
even if they also, it might be that they're in both in relation to some of those examples.
It does give paragraph 1F, the final words, a far more restricted scope than on their face the words would appear to bear.
Well, that rather depends on which of the examples you plump within both or either. But my respectful submission is if you've got a choice between a relatively narrow reading of those tailpiece words and all of the dramas that I've gone through and I won't repeat, then it's a pretty straightforward choice, I submit. At least the argument is there.
Your point, I thought, was that this reference to arising by virtue of the Act about reserved matters reflects the fact that there are a number, as you've provided us with, of provisions of the Act that do generate questions about reserved matters.
And one wouldn't
using
need
that term, whether or not they're also
in
raising
Part A.
questions about evolved competence. Maybe they didn't want to.
I mean, you can see that you can see the mind of the draftsman working. I'm tracking the wording. I can see lots of provisions where the wording of the Act uses that as a unique concept. Maybe that it gets crammed into some other concept as well, but it's being used in that way to cover those things.
Well, the final words are any other question.
Yeah.
So it's any question other than the question about whether a function is exercisable within devolved competence.
Oh, Lord, yes, it's a discrete category. I entirely accept that.
Yeah. Well, so far it seems to be a category which has extremely few members, but you say, so be it.
I do. I don't want to say so be it too often, because otherwise you'll start not paying attention as you should to the strength of the submission that otherwise exists. Anyway, my Lord, those are the provisions I wanted to draw attention to. I hope not unhelpfully, because at least it shows the wording being tracked through the legislation, fully accepting any other question arises, but you've got something there that refers to everything. And if there's an incoherence, if that's the point that's being put to me by Lord Reid, between the breadth of those words and the fact that the reserved category, if it's any other question, is relatively narrow, I respectfully submit that at least does provide some real workable sense to the words in a way that does not open up what I described as the bull point of incoherence against the Lord Advocate's case, which is that it is entirely unexplained and inexplicable that Parliament would have referred to reserved matters only in the context of concerns about whether or not you could introduce a draft bill under 31, where all of those concerns would base, or could base, entirely properly, in any of the matters referred to in subsection 2 of section 29. Just to finish this bit, Lord Stevens, I know, raised a question, and I know my Lord the President did too yesterday, about whether there was any wisdom to be derived from the position in Ireland, and we've tried to do a bit of research in relation to that. Can I give you very briefly the fruits of that research, for good or ill? Lord Stevens queried the suggestion by the Lord Advocate that reserved matters were a new concept, and you were right to do so, I respectfully submit. Section 414 of the Government of Ireland Act 1920 provided that the Parliaments of Northern and Southern Ireland did not have power to make laws in respect of reserved matters, which were then defined in section 9 of that Act.
I think it went back further than that, in fact, actually, because the colonial administrations also, I think, adopted reserved matters as a method, as a drafting technique.
Yes. I think it was the same concept of reserved matters in a slightly different way in which the test was set up under that Act. It was in respect of reserved matters rather than relating to. Yes. So it was slightly tighter, but it doesn't bear on the point that you were interested in. The concept of reserved matters was also used in the Northern Ireland Constitution Act of 1973. Both of these have now been superseded, so we haven't provided them to you. The Northern Ireland Constitution Act 1973, the Northern Ireland Assembly was required to obtain Secretary of State consent to measures it passed dealing with a reserved matter. They were then defined in Schedule 3 of that Act. Lord Reid then asked about whether or not there were terms, or about the terms of the equivalent provision to 1F in 1 sub D of Schedule 10 to the Northern Ireland Act. That's the corresponding provision to 1F. As we noted in footnote 3 of our case. I'm afraid we've drawn a bit of a blank here because we haven't been able to identify any available contemporaneous explanatory notes or notes on clauses, or indeed any other documentation relating to the bill that elucidates the tailpiece wording. And nor have we been able, I'm afraid, to find anything in Hansard that bears on any of that. But I suppose the most that can be said in relation to those provisions of the Northern Ireland Act is that they raise essentially the same issue. We don't suggest that there are materially different words in the Northern Ireland legislation. We respectfully agree, if this was the point being made, that the same issue arises in relation to Northern Ireland. And just in case anyone felt we were leaving Wales out of the equation, we had a bit of a think about the Welsh legislation. And as we understand it, in the Welsh legislation, there is no 1F equivalent. Now, why that should be is a matter shrouded in the mists of history. I mean, it may or may not be related to the fact that it was a conferred powers model, but we haven't been able to identify any equivalent provision in Wales. So there's a slightly strange mismatch between
the structure of the Act is
the structure of the Act is very different, and maybe that's the explanation of it. But there isn't an equivalent in Wales. So I hope that at least tries to chase down some of those issues. For all of those reasons, sorry, it's taken a while to get through them, but the arguments are somewhat convoluted, given the structure and terms of and the complication of the provisions in the Act. That's what we have to submit about jurisdiction and discretion. Of course, we are, by which I mean you are, where you are. The Court wished in its permission consideration, it wished to examine, if that's the right way of describing it, it wished to examine all of the circumstances, including the substance of the question referred together. See page 35 in the electronics for that decision as to how this reference should proceed, with all of the issues being thought about and determined by the Court together. Of course, there are a variety of potential outcomes in relation to and strengths of views that might be formed as to the competence question or the reference question, to which I'm going to come directly. The Court may consider that there's a very clear answer to that reference question, and that, to come back to a point that my Lord Stevens was putting to me earlier, is it really realistic to suppose that the essentials of this are going to change? And we see the force of that. The Court may consider that the answer would inure, if it's clear enough, in relation to any bill with a subject matter of this kind designed to set up this sort of referendum, and it isn't going to turn on the intricacy of the individual legislative provisions that might or might not sit in a draft bill. And if that is so, if the Court does reach that position of clarity, then we can respectfully see good sense in the Court saying so. But the jurisdiction issues are of broader significance, which is why I wasn't prepared to accept the entirety of the point my Lord Stevens was putting to me yesterday, because these are issues of general interpretation that might apply in relation to a very simple bill, or in relation to no bill, or in relation to a bill which is extremely complicated, and the same essential interpretive exercise would have to be grappled with. So that's why I've taken a little time to go through some of that detail. My Lords, my Lady, unless there were further matters on which I could seek to assist in relation to jurisdiction and or discretion, I was going to move on to the reference question.
No, I think you've given us plenty of food for thought.
So the reference question. Just by way of introduction, the basic approach we respectfully submit to how you as a court go about approaching reference questions is clear from the case law. You interpret the Scotland Act in the same way as you would interpret any other statute. The aim is for a, quote, consistent and predictable interpretation so that the Scottish Parliament has a coherent, stable and workable system within which to exercise its legislative power. That's a quote from UNCRC at paragraph 7, page 911 in the electronics. I don't invite you to turn it up because of the lack of controversy about that proposition. The extent of that legislative power is, of course, as the Court has repeatedly made clear, derived and only derived from the statute which creates the Scottish Parliament. The reservation in question deals with the Constitution, Schedule 5, paragraph 1, that's the relevant title, and it sets out, quote, aspects of the Constitution, see Schedule 5, paragraph 1 on page 183, that are reserved. It's for the UK Parliament alone to legislate for matters relating to those constitutional arrangements. one of the, quote, aspects of the Constitution that is referred to is the union of the kingdoms of Scotland and England. That was described by the Supreme Court in the Continuity Bill case at paragraph 60, page 846, as, quote, one of the fundamental elements of the Constitution of the United Kingdom. So the only question is whether the provisions of the draft bill as presently constituted relate to that part of the United Kingdom's constitution, in other words, the Union. And I reiterate that the reservation is of the Union, not the dissolution of the Union. An act of the Scottish Parliament which relates to maintaining the Union would be just as outside legislative competence as one which relates to dissolving the Union. And my submission is that there is the clearest possible answer to the question that Schedule 5, paragraph 1 poses, whether or not it relates to. I wanted to start very briefly with the principled approach that the Court takes to those questions, and in particular to focus on the principled approach to the concept of relating to. You may not need much on this because it might be thought you don't need to engage too much in the fine graining of those principles given the clarity of the answer, but 4 points on the principles, if I may, from which we say the answer to the question inevitably flows. Firstly, the basic analysis involves asking whether the scope of the subject matter of the relevant matter reserved by Schedule 5, asking what the scope of that is, and then asking whether the provision in question relates to that. See our case at paragraph 65 for the references for that proposition. Some of the cases turn on the first question, some on the second. Here there's no real doubt about the scope of the reservation. The issue relates to the second question and whether the draft bill relates to it. So that's the basic analysis, that's the basic stages of the analysis per the case law. Secondly, the question whether something relates to a reserved matter, so as to be within or outside competence, is a question to be determined applying section 29(3) by reference to, quote, the purpose of the provision having regard, amongst other things, to its effect in all the circumstances. So purpose is the driving and predominant thing in that mandatory canon of interpretation. I wanted to focus first on purpose briefly and then on effect, taking up that language. Purpose, says the case law, requires focus on more than can be discerned from an objective consideration of the effect of the terms of the provision. More than can be discerned from an objective consideration of the effect of the terms of the provision. That's paragraph 50 of the Agriculture Bill Wales, per Lords Reid and Thomas at page 666. A statement that was then specifically endorsed in Christian Institute, Lords Reid and Hodge and Lady Hale, Christian Institute, paragraph 30, page 791. And I emphasise that because section 29(3), as is evident from its terms and as is evident from that description of the principled approach to purpose in those authorities, is not a pure objective question of statutory interpretation. Statutory interpretation is the exercise of seeking the meaning of the words used by Parliament by reference to, amongst other things, its purpose. Here, as it were, it's reversed. You're seeking the purpose of the legislation from, amongst other things, the meaning of the words. That's a fundamentally different exercise. It's even a different exercise, I respectfully submit, from the statutory interpretation exercise that would be engaged under an HRA or ECHR challenge, although that's some way down the line towards this 29(3) principle. And as such, because that's the basic nature of the exercise that the Court is enjoined to undertake under 29(3), that does entitle and may require a court to consider the aims of those who introduce the bill. In Agriculture Bill, for example, the purpose and effect derived at paragraph 54 from both the purpose of those introducing it, that's the bill, and the objective effect of its terms. See paragraph 54, page 667. In Martin and Most, Lord Kerr held that the statements of those responsible for the legislation purporting to identify the reasons for its enactment were relevant to the section 29.3 exercise. See paragraph 162 of Martin and Most at page 441. So 162 is the paragraph, 441 is the electronic reference. In the inner house in Imperial Tobacco, Lord Reid held at paragraph 122, page 589 of the authorities bundle, the focus is primarily on why the provision has been enacted rather than what it does, and the motive and policy of the legislature is relevant. So you are often using documents accompanying the legislative process, as the case law also makes clear. We've given you a series of examples of that being done in our case at paragraph 13, and Martin and Most and the agricultural bill cases provide further examples. I think Lord Stevens asked yesterday whether or not documents such as party manifestos, etc., can be admissible, and we respectfully submit that there's no reason in principle why not. You are seeking under this set of provisions to identify the purpose of a bill, including by reference to the purpose of those responsible for it. That's, as it were, the change that section 29.3 makes to the ordinary approach to statutory interpretation. And it might be thought that the core question in relation to purpose, that part of section 29.3, is helpfully encapsulated at paragraph 43 of the Supreme Court's judgment in Imperial Tobacco, para 43 at page 650 of the electronic bundle, the core question being, what are the provisions really about? So far as effect is concerned, to move to that concept, that is a reference, as Agriculture Bill at paragraph 53, page 666, makes entirely clear, that is a reference to, quote, legal and practical effects. Legal and practical effects. You have to look at the realities. And a good example of this, it might be thought, is Imperial Tobacco itself, where the legal effects were the prohibition of the display of tobacco and on its sale in vending machines, but the purpose of those effects, what they were really about, was the promotion of public health. There is, of course, no dispute that practical effects ought not to require undue speculation. That's just a basic principle of common sense. But a natural inference is perfectly permissible. In Imperial Tobacco in the Inner House, Lord Reid considered the short-term practical consequences, as he put it, of the prohibitions at paragraphs 133 to 134, page 592. So 133 to 134 is the paragraph, or are the paragraphs, and 592 is the electronic reference. And those short-term practical consequences in the example of Imperial Tobacco were they would reduce sales and were thereby consistent with the public health purpose. That was the basic practical, short-term practical consequence that was identified. And the legal and practical effects were also considered in Continuity Bill, paragraph 33. The retention of EU law after exit did not relate to the reservation of relations with the EU, because the legal effect of those relations would be zero, because they only took effect after exit with no relevant relations left, and there was no practical effect on the conduct of exit negotiations. So again, both of those aspects, practical and legal, being...
That's paragraph 33 at page...
Paragraph 33,
sorry.
838, thank you.
Thank you very much.
Sorry.
Thank you.
So that's the second proposition, determined by reference to the test set out in 29.3 as exemplified and explained in the case law. Thirdly, to come closer to the nub of the dispute, it appears of principle between us. Relates to is, as Lord Walker put it in Martin and Most, finely modulated language which carries the ordinary meaning of more than a loose or consequential connection. Finely modulated language is in para 46 on page 405, and more than a loose or consequential connection, that well-known phrase, is Lord Walker at paragraph 49 of Martin and Most, page 407. And of course everyone accepts that relates to must have some limits, or must, as Lord Kerr put it in Martin and Most at paragraph 159, page 440, must be suitably restrained, because otherwise section 29(4) of the Scotland Act would be unnecessary. So not everything which affects, to take the word, a reserved matter, however slight, indirect or remote the effect may be, taking those words from Lord Reid in Imperial Tobacco at paragraph 120, so not everything which affects a reserved matter, however slight or indirect or remote the effect may be, 120 at page 588, Lord Reid in the Inner House in Imperial Tobacco, is covered. What you need is more of, and I underline notionally more of, a direct connection, to come to that phrase, much beloved of the Lord Advocate. What the case law makes clear is that in some circumstances you need more of a direct connection than everything which affects a reserved matter. That is essentially what Lord Mance is saying at paragraph 27 of medical costs, which you were taken to yesterday, and I don't go back to it because you'll be very familiar with the passage. That's paragraph 27, Lord Mance, page 735 in the electronic references. We do, however, invite you to note when you go back to those paragraphs, particularly 25, 26 and 27, we do invite you to note that he was not laying down direct connection as a test. He was merely using that idea to indicate degrees of connection sufficient to come within the concept of relates to. And he was then applying that to the facts of the individual and particular case that he was then considering. And the reasoning is, as you see, summarised in the relevant parts of that judgment. You will note, just by way of basic structure of that part of the judgment, that he'd already set out the Lord Walker test, if I can put it that way, more than a loose connection. He'd already set that out in defining and describing the principles at paragraph 25. And he noted specifically in paragraph 25 some of the many cases in which that language and no other language had been recently and repeatedly approved and applied by the court. That's this court. And he says he's then going to apply the same test to the Welsh legislation he was having to consider. And his conclusion at 27 is that section 2 of the legislation in question had at best an indirect, loose or consequential connection. It's clear from that recitation that he wasn't intending to impose some reverse test that the connection must be direct. He'd set out the principles. If he was going to alter the principles or thought that was what he was doing, then the obvious and natural place for that to be done as an amendment to or alteration of or tightening of the Lord Walker language was in paragraph 25 when he was dealing with the principles. He didn't do that at all. And indeed, given that it was Lord Mance who was producing the judgment, it might be thought that if he was intending to gloss Lord Walker's test, as the Lord Advocate appeared to submit yesterday, one would have expected him to say so in pretty clear terms and explain why he was doing that and why that was an appropriate thing to do, having regard to the structure or content or the purpose or whatever it was of the Scotland Act. Would have been a thoroughly material departure if he'd moved from the position of Lord Walker to a position which requires a direct connection as part of the inherent in or as limiting relates to direct connection. He did nothing of the sort. So we respectfully submit that that submission of principle by the Lord Advocate is untenable, effectively, on a true and fair reading of paragraphs 25, 26 and 27 of Lord Mance's speech, and indeed is perhaps its main significance as a submission is that it indicates implicitly that my learned friend recognises that she has to make that submission in order to make the rest of her argument work. She has to win that argument of principle. If she can't win the argument of principle, the case becomes a great deal more difficult in its later stages. The fourth submission of principle that we invite you to have a think about is that the provision in question does not have to modify the law applicable to the reserved subject matter in order to relate to it. So there doesn't have to be a legal effect in that sense. That's the point that's made by Lord Reid in Christian Institute at paragraph 33 and at paragraph 63, pages 793 and 804 for those two paragraphs, 33 and 63. 33 and 63 on pages 793 and 804 respectively. And it's evident that that is so, not least from the statutory language, from the contrast between relates to in section 29(2)(b) of the Scotland Act and 29(2)(c), page 129 of the bundle, referring to a breach of restrictions in Schedule 4, paragraph 2, which includes provision or preclusion against modifying the law on reserved matters. That was the basis for the point that Lord Reid, Lord Hodge and Lady Hale were making at paragraph 33 of Christian Institute. So those are the 4 points I wanted to emphasise by way of submissions on the principled approach to the concepts that you're going to have to grapple with. So what then of the answer here? We make 3 submissions as to the application of those principles here. Firstly, the subject matter of the matter reserved is the aspect of the United Kingdom Constitution that is the Union. It's entirely unsurprising that that aspect of the Constitution that is the Union is reserved to the UK Parliament. And that is because it self-evidently affects the whole of the United Kingdom. The impacts and effects of Scottish independence would be felt throughout the United Kingdom. All parts of the United Kingdom have an interest in that issue, not just Scotland. And it's obvious why it's reserved to the United Kingdom Parliament. It's of critical importance to the United Kingdom as a whole. The Union is the constitutional foundation of the modern British state. It's equally obvious why the Union could not be a matter over which the Scottish Parliament has competence. It would be fundamentally at odds with the purpose of devolution to grant powers to a Scottish Parliament within the Union. But the point about it being of that ilk, because it affects the whole of the United Kingdom, was precisely the point that was made by Lord Hope in Imperial Tobacco. That's the moniker, as it were, for whether or not it's reserved and how you judge whether something is reserved and what the limits are. That's the point made by Lord Hope in Imperial Tobacco, paragraph 29, page 45 in the bundle. And that was then cited with approval. That very point about affecting the whole of the UK was cited with approval in Christian Institute by Lord Reid at paragraph 28. See for that purpose page 790. And indeed, to those references we add Lord Hodge's recognition in Muan at paragraph 17 that a referendum of this kind would be, as he put it, a very important political decision for both Scotland and the rest of the United Kingdom. See paragraph 17 of Muan at page 684. And of course, Muan was in the context of the 2014 referendum. That's the first submission. The second submission is that the key provisions of the draft bill are self-evidently, squarely and directly about the Union. The draft bill, if introduced and passed, would set up a referendum that is, as my learned friend the Lord Advocate was positively at pains to emphasise by reference to Dicey, who is somewhat ambivalent on some of these issues, but on this obviously correct, that is the most targeted form, to put it neutrally, of seeking electoral views, as this court is well aware from all of the Brexit issues that arose. The referendum which the draft bill purports to legislate for would be the very question whether, in the view of those participating, the Union should continue, whether Scotland should become an independent country, to take the referendum question proposed. The Union, if that happens, would end. You don't need minutely to cut purpose and effect. They are both obvious here and they coincide. But for good measure, if you're asking the question that I identified as a neat summary with respect to what the purpose aspect of 29.3 is about, what are the provisions really about? They are about seeking the views of those entitled to vote in the referendum for the purpose of furthering the Scottish Government's avowed aim to end the Union and to make Scotland independent of the United Kingdom. So the Lord Advocate's case has to be that legislation which would directly regulate a referendum on the very subject matter that is reserved does not even relate to that subject matter. That, we respectfully submit, is untenable as a submission. The Union is the very and the sole object of the referendum that the bill purports to set up. That's why it's being put forward. And that is why, no doubt, the explanatory notes, to which we've already made reference, provide precisely this sort of legislation, setting up a referendum on Scottish independence, as the paradigm example of proposed legislation that is not or would not merely be not within competence, but so clearly not within competence as to render it impossible to use the strong interpretive principle in section 101, which is some of you will recall we considered in some detail, or you considered in some detail in UNCRC. See for that purpose page 376 in our case at paragraph 81. Thirdly, third submission, the fact that the referendum is not self-executing does not support, still less mean, that the draft bill does not relate to the Union. Of course, the position is that even if the referendum had been within competence, the position would be as summarised by Lord Neuberger in Muan at paragraph 47, page 694, remember the bit where he said everyone will have to vote with their conscience because it's not self-executing. So it will still be a matter for the Westminster Parliament to determine whether or not to do anything about that. That doesn't mean that the bill doesn't relate to the Union. The draft bill will be legislation directly to do with and intended to create effects on the constitutional arrangement of the Union. It relates to the Union whether there is immediate and direct legal effect flowing from that result or not. The bill, if it were to be introduced and became an act, would provide the legal basis for the referendum. And that is why there has no doubt in recent days been repeated emphasis by the First Minister on this court's process as being one of invitation to you to, as she put it, pave the way for a lawful referendum. Evidently, the purpose of the draft bill is not just to have an opinion poll, but to seek to take advantage, political advantage and other advantage, of this being a referendum conducted under the authority, whatever its legal effects, of an act of the Scottish Parliament. With, we would add, no doubt a suggestion that decision, were it to be held to be within competence, had in fact been devolved by Westminster to the Scottish Parliament, at least to that extent, and thus creating further weight to some implication that something should at least follow from a positive outcome of the kind which the Scottish Government no doubt hopes for. To focus slightly, but only slightly, more broadly, focusing on the referendum that the bill purports to provide a legal basis for, the Scottish Government are evidently setting that process up for a purpose. It is entirely clear, if one's adopting a realistic, any form of realistic approach to this, it is evident that they consider and intend that the referendum will further the cause of independence. That's no doubt why the draft bill would have been introduced, but for the intervention of the Lord Advocate's view under Section 31, would have been introduced and would have been supported through the Scottish Parliament by the Scottish Government as presently constituted. And if it was answered in the way that they no doubt hope, it's perfectly obvious that they will regard that as an important step towards the termination of the Union, which they will present as a strong and targeted democratic mandate for their cause. In Lord Reid's language from Imperial Tobacco, one only really needs to look at the short-term practical consequences of the referendum outcome either way to see the link to the Union. And indeed, there's no secret about any of this. See the references that we've given you in our case at paragraph 75 and that are set out in the Lord Advocate's own case at paragraph 109. And those sorts of matters are relevant, as I've explained, to identifying the purpose of the bill. So the First Minister's statement to the Scottish Parliament in connection with this reference on the 28th of June makes clear that she wishes to introduce and pass the draft bill to further the cause of independence. See page 6499 for that purpose. See also another Scottish Government Minister's official comment in connection with this reference to the same effect. See page 6497. See the most recent SNP manifesto, if you need that for the entirely self-evident factual proposition for the Scottish Government 2021 elections at 6361. The Lord Advocate goes as far as to say, or to submit, that the legal effects of the draft bill are, as she put it in her written case and has put it to you orally, relevantly nil. Even if that is accurate, that is both an ironic and an irrelevant plea. It is not even an accurate plea. There is a need for statutory authority in order to authorise the significant public resource that would be needed to conduct a referendum. Clause 4 of the bill, page 14, needed to apply the Referendums Scotland Act of 2020 to the conduct of the referendum. Section 7 of that Act needed to give power to appoint a chief counting officer for the referendum, whose functions are then set out in Section 9. Section 11 of that Act, that's the 2020 Act, authorises the chief counting officer to recover the cost of the referendum. And to give some insight, the Scottish Government predicted in 2010 the first referendum would cost in the region of £9.5 million. See 5777 in the electronic. At one point in our oral submissions yesterday, the Lord Advocate asserted that the referendum needed to have a legal effect on the Union to be sufficiently directly related. Well, she's wrong about directly related for the reasons I've given, but she's also wrong to adopt a test which requires a legal effect. That is, we submit, to fall into the error identified by the Supreme Court in Continuity Bill at paragraph 51 of conflating a Schedule 5 reservation with a Schedule 4 restriction on modification. If all that the United Kingdom Parliament was seeking to achieve in the Schedule 5 paragraph 1 provision was to prevent the Scottish Parliament from legislating to end the Union, it need only to have listed Article 1 of the Acts of Union in paragraph 1 sub 2 of Schedule 4. It didn't do that. As the court put it in paragraph 51 of Continuity Bill, page 843, quote, when the United Kingdom Parliament decides to reserve an entire area of the law to itself, it does so by listing the relevant subject matter in Schedule 5. That's the point being made by the Supreme Court in Continuity Bill. And here it is evident that the United Kingdom Parliament has reserved the entire area of the Union to itself. And that must include, we submit, must include laws enabling referendums about whether the Union should continue. The Lord Advocate said that questions of legislative questions could be debated by a whole variety of bodies, including the Scottish Parliament, even if those debates related to reserved matters. My submission is that it doesn't assist the statutory question of legislative competence to look at whether or not the Scottish Parliament holds debates to discuss and may indeed pass motions about matters on which it could not legislate, or whether the Scottish ministers could negotiate with the United Kingdom government about the terms of changes to the competence boundaries when they do not have power to do the things that they wish to do. The 1998 Act and the competence limits established in Section 29 set careful controls on the exercise of legislative powers, that views may be expressed about reserved matters, and Scottish ministers may listen to them and seek them and reflect them to the Scottish Parliament or the UK government is entirely unsurprising, but also entirely uninformative for the purpose of this reference, which is concerned with legislative competence. I've focused on the Union, and I've nothing really to add in relation to the separate reserved matter of the Parliament of the UK, which is dealt with in our case of 86 to 88 and engages essentially similar points. I also don't propose to engage in any detail at all with the written response that we've made to the intervention of the SNP, and particularly to the reliance which is there placed on the principle of self-determination in international law. I've nothing further to add orally. That is a set of arguments which we respectfully submit and have submitted in our written response fails at almost every analytical stage. So in conclusion, we respectfully invite the court to agree with the Lord President in Keating's at paragraph 66, into which paragraph one has to interpose, one suspects, at least a drop of irony, that the answer to the question whether such a referendum bill will be within competence is not too difficult or might not be too difficult to discern. We agree also, I should make explicitly clear, with the Lord Advocate in considering herself correctly unable to support a within competence statement. This is, to put it at its lowest, a strange reference legally. It comes to the court in circumstances in which the Scottish Government has not even felt able to introduce a bill into the Scottish Parliament on the apparent basis that their own law officer is unable to say that the bill will be within competence. And it comes to the court in circumstances in which it is perfectly obvious that the Scottish Government want to produce legislation in Scotland in order to advance, as they see it, their avowed political agenda of independence and thus ending the Union. And yet, in the same breath, they seek to assert that their draft bill does not even relate to the Union. If, in this context, this draft bill does not relate to the Union, it requires an interpretation of the words relates to, which is contrary, we submit, to all of ordinary language, this court's consistent case law, and common sense. And that is neither a coherent nor, we submit, an attractive place for them to be, or to submit that the court should find itself in. So for those reasons, if you get to this stage, we invite you to answer the reference question in that way. My lords, my lady, unless there were further matters on which I could seek to assist, those are my submissions.
No, thank you very much, Sir James.
Grateful.
Lord Advocate.
Yes, thank you, my Lord. I wonder, my Lord, I note that it's 1:45.
Yes, and
In the course of Sir James's submissions, I was given for the first time an understanding as to why this document was produced this morning for me at 10:30. So I wonder if I might be given the opportunity to reflect on what he said over lunchtime and to come back at 2 o'clock and hopefully complete matters by my response, and it will be more focused than I could probably do at the moment.
Yes, that's fine. I should say that we've also received electronically during the course of the morning, in addition to Sir James's additional material, also additional material on behalf of the Lord Advocate. I don't know if Sir James has this. As you've been on your feet, you won't have been able to see it. If new material is going to be referred to in a reply, then we'll have to give you an opportunity to respond.
Very grateful. Someone might provide me with a copy of whatever it is.
I think the copies have been given, my Lord, and the document, I think, relates to the point that was raised yesterday about the process involved in a private member's bill.
Yeah.
Thank you.
So if we resume at 2 o'clock, will that give you sufficient time?
Yes, that does. Thank you.
glad to see you on your feet, Sir James, because I had a matter of housekeeping to raise with you.
Right.
We were looking previously at page 379 in the Bible.
371.
No, 379.
379, I'm so sorry, yes.
The explanatory notes relating to paragraph 1F.
Yes.
And you'll see that the first example given is a question relating to the making of orders in council.
Yes.
And it says, see note on section 118.
We don't have that.
Yes, it would be helpful if you could provide us with that.
We certainly will. And my Lord, that was with the Lord Advocate's permission and apologies. I said I might come back and have a further think about section 54.
Yes.
And I have done in the context of inter alia, page 379, which you've just drawn attention to. I think section 118, or for present purposes, what you need to know in relation to that example is that the making of an order in council by Her Majesty of that kind would be an act of, in effect, of the Scottish Government under section 118. And it was to that I wanted to return a little bit. If you just go back in the bundle to 322, back to the well-known words of the tailpiece and Schedule 6, paragraph 1F, it may be helpful just for the purpose of this analytically, just to put another number or two in there. So what I'm going to call F1, F Roman 1, runs from any other question about whether a function is exercisable within devolved competence or in or as regards Scotland, draw a line, and F2, any other question, because as my Lord pointed out, they're distinct categories, that's why it's any other. I mean, you could put an A and a B if necessary, and it might be helpful for the purpose of understanding the explanatory notes to which we've just gone, put an A and a B, an A before within devolved competence, and a B before in or as regards Scotland. The point I wanted to draw attention to is that, and it may be that this has got home anyway, but in case it hadn't, is that all of the examples in the clip that we handed up this morning are examples falling within F2, i.e. the tailpiece, what I keep calling the tailpiece, and not F1. And that is because they all relate specifically to reserved matters as conditioning the powers, and only reserved matters as conditioning the powers, and they are to do with functions of the Scottish Parliament, to which devolved competence doesn't apply for obvious reasons, or UK ministers, to which again devolved competence doesn't apply. And devolved competence, as my Lord drew attention to, is a defined concept and dealt with in section 54. And so, as you will recall, although again I think this might have to go on in the box marked section 118, and we'll provide you with a copy of that as well. But section 54 deals, as you will recall, in sub 2.
Remind me of the page number.
It's not, I'm afraid, in the bundles. It's one of the ones that the Lord President drew attention to, and we'll provide it to you. But sub 2 of 54, just for your note, deals with things being outside devolved competence when you're making, or it would be Scottish ministers would be making, because that's what devolved competence is about, making subordinate legislation. And sub 3 is about Scottish ministers exercising functions of any other kind, i.e. not making subordinate legislation. And in both cases, whether or not something is within or without devolved competence, see back to the words of paragraph F1A in my new numbering and lettering system, they're all controlled by the same competence things that control the competence of the Scottish Parliament to act. So they've effectively dragged over that competence concept from the Scottish Parliament and applied it to subordinate legislation in the exercise of functions by Scottish ministers. And so when you're looking at F1, the core points to bear in mind are that is all to do, in effect, with functions, whether delegated legislation or subordinate legislation or otherwise, of Scottish ministers. And perhaps unsurprisingly, given the definition of devolved competence in section 54, which we've just seen in 2 and 3, that is all controlled by competence. That's why the word is used in that way in F1. See, by contrast, what I call F2, i.e. the tailpiece, which only refers to reserved matters and is, for the reasons I've shown you in the little clip, all to do with UK ministerial power and its conditioning, and or conditioning on the powers of the Scottish Parliament in certain spheres, and therefore not within F1 and controlled by competence. This one is controlled by reserved matters, where that concept is specifically referred to as the moniker for control on the power.
So you started your explanation by saying that when making an order in council of that kind, and then you went on. So does the Scotland Act provide for making of orders in council of different kinds? I suppose at least that must include when an order is made to distribute matters under Schedule 5.
Yes, and I think it's to do with the transfer of, can be to do with the transfer of functions and so on. But I think the 118 example tells you that this example in this on 379 is an exercise of function by Scottish ministers.
I mean, 118.
I hope I got that right. I haven't got
118 it is concerned with the exercise by a member of the Scottish Executive within devolved competence. This is in the original statute, which is what the notes are commenting on. The exercise by a member of the Scottish Executive within devolved competence of a function to make, confirm or approve subordinate legislation. So there is no specific mention of orders in council, but I think orders in council fall within the definition of subordinate legislation.
I think they would.
So, and you tell us that the minister is regarded as making the order in council, notwithstanding that it's...
As it were, notionally, notwithstanding that it's Her Majesty for this purpose. I think that may be the effect of section 118. But the key point for present purposes is that all of these other examples, apart from the one that I referred you to this morning, i.e. the very tailpiece of those examples on 379, where the functions of a body relate to a reserved matter, all of the examples that are given before that are all within what I call F1.
Yes.
Because they're either raising a question about devolved competence, which by definition is a matter engaging the exercise of power by Scottish ministers, or they're in or as regards Scotland. So F1B, if that makes sense.
Yes.
That shows that distinction is being deliberately drawn by the draftsman. And as I say, the core point I wanted to make, in case it was a question that was still live and floating as a result of the submissions this morning, was that all of the examples in the new little clip are all examples of specific references to reserved matters. They're not examples within F1, because by definition they're to do with acts and matters. All of these examples are to do with acts and matters of the Scottish Parliament and or UK ministers.
So are you saying that whereas this morning you were suggesting, well, perhaps they all fall within both, actually now you're saying they're mutually exclusive?
They do look as though they are, which is more consistent with the structure of it. So apologies if that impression was given. I think Lord Reid was testing that proposition this morning, and on reflection he's right to do so.
And just, sorry, to make sure I understand it, the first part of paragraph 1F, then you say is, and perhaps I've misunderstood this, restricted to subordinate legislation. Is it?
No, because Scottish ministers, the devolved competence issue can apply to Scottish ministers when making subordinate legislation under 54.2 and when making or when exercising other functions under 54.3. The point is that it's Scottish ministers, because devolved competence doesn't apply to the UK Parliament or to UK ministers, whereas reserved matters, i.e. F2, are referred to in the Act, and they all refer to the acts of the Scottish Parliament and the UK ministers. So they all refer to the acts of all the examples here refer to the acts of either the the Scottish Parliament, or UK ministers. So they are discrete categories in that way, and I think Lord Reid was questioning that. He said any other question arising by virtue and so on. So, yes. And I'm effectively agreeing with that and explaining why. Yeah. But it does bear out and reinforce the point I was making this morning about the meaning that you give to reserved matters and arising by virtue of this Act about reserved matters in F2. Mm-hmm. I'm sorry, that's rather a convoluted way of going back. But I hope.
Just following 54.3, it's in the case of any function other than a function of making, confirming, or approving subordinate legislation. Yes. That is dealt with in that's F2.
Yes.
It's outside devolved competence. If the legislation giving the function was outside the legislative competence of the Parliament.
Or would be, yes.
Or would be, yeah. And so what you're postulating there is some other legislation passed by the Scottish Parliament, and they're exercising a function under that other legislation.
I think that's the way in which 54.3 works. Yeah.
Yeah.
Yeah. Yeah. So it's different from their act of making subordinate legislation. It may be a narrow range of functions, but that's how they define whether it's within or without competence.
So the examples you gave us from the Scotland Act are all under that Act, as opposed to under other legislation passed by.
They're all under these are all under the Scotland Act. Yeah. Exactly.
There is 54.2 dealing with where you have an Act which is within competence, but the regulation or subordinate legislation making power is actually exercised in a way which is outside competence.
Or would be if it was put into an Act of the Scottish Parliament.
54.3 is dealing with where the primary legislation is itself outside competence, then any subordinate legislation made under powers in that Act are also outside competence.
I'm not sure. Is that bit right? No, 3 is in the case of any function other than a function of making, confirming, or approving subordinate legislation. So it's cutting out the exercise of making subordinate legislation or things to do with that. So it's a broader set of functions than legislative, if that makes sense. And it's then defining the test of competence by reference to what would be the position were it to be done under an Act of the Scottish Parliament. So there's a hypothetical test of competence.
And in practice, the function might well be conferred by UK legislation.
Could be.
And in that event, the limits on devolved competence would only bite at the stage when the function was being exercised by a minister.
Yes. But I come back to the core point. And the core point is that, as was tested by Lord Reid this morning, F1 and F2 are about different things. To take it at its most simple, F1 is about the exercise of power by Scottish ministers, legislative or otherwise, or if something engages the question in or as regards Scotland, and F2 is exemplified by and applies to, as a separate category, in the examples I gave you in the little clip, to things done by the Scottish Parliament and all UK ministers.
So your F1 actually is 2 categories. Are you able to help us with the second limit, or in or as regards Scotland? Does that marry up with some specific language in the Scotland Act?
Yes, there is. There are. I'm not sure I've got them here, but there are provisions that require certain matters to be in or as regards Scotland. I'm sure we can give you a little list of examples.
If a note's coming in, I think it would be useful to
see that. But it is a separate category. That's why I suggested putting A and B in there.
Yeah. Can I raise with you? I'll let you do it.
Yes. No. Sorry.
No, by all means, deal with the. Well, can I raise with you another way of looking at this? When the legislation was, when the Scotland Act was being drafted, it was necessary to draw up lists of devolved, of reserved matters, which we have in Schedule 5.
Yes.
And as we've we discussed earlier, sometimes they're very specific, other times they're much broader. And inevitably, questions were going to arise as to whether a particular subject fell within the scope of reserved matters or did not. And commonly, there are going to be disputes. I mean, this is something which the Lord Advocate may be able to comment on in due course, but it seems to me that commonly there would be disputes between the Scottish Government and the UK Government over the demarcation of responsibilities. And one would imagine this happens week in, week out. The issues in agriculture, trade and industry, road traffic, all sorts of areas where the view may be taken by the Scottish Government that this is something we can do, and the UK Government may take the opposite view. Now, very often they'll be able, no doubt, to arrive at a solution by negotiation.
Quite.
Sometimes they might not be able to.
In which case you might need an order under Section 30.
There might be, it's not inconceivable that there might be an unwillingness to make a Section 30 order.
That's true too.
Now, in that kind of situation, there are in principle, there are two ways forward. One is to have some sort of arbitrator who can determine the issue. The other is to litigate, and or just to go ahead and wait for somebody to take proceedings against you. It occurs to me that 1F2, as we're calling it, might be designed as a means to enable the two governments to have demarcation disputes resolved.
My Lord, the difficulty I think with that, I don't want to go back over submissions I've made, the difficulty I think with that is that although of course reserved matters might be thought to be at the core of all of this, it doesn't provide a very good explanation as to why that wording is used in contradistinction to the word competences in F1, for example. I know they're dealing with different things, but you've specifically referred to reserved matters, and there may be points of controversy between the Scottish Government and the Westminster Parliament about other matters that bear on competence under 29(2), for example.
Well, there might, but they might not be quite as sensitive.
And also, I mean, the dividing line between, if you like, the authority of the UK Parliament and the authority of the Scottish Parliament is the dividing line based around reserved matters. There may be disputes about the other things, but that's the division of authority between them.
Yes, they're both alike, obviously, bound by convention rights, insofar as those have a binding effect. When the legislation was being prepared, they would both have been bound by EU law. But those don't give rise, that's a common restriction that they're both under. They don't give rise to what I'm calling demarcation disputes, whereas reserved matters do.
And restrictions in Schedule 4. I mean, there are just certain difficulties with that. And if you say, and again, we discussed this before, a short adjournment, but if you say, well, that's the basic purpose, it's a really quite core purpose. It means that whenever an issue of dispute about demarcation arises, you don't need to worry about any of the provisions that say, actually, this has got to reach a certain stage of fruition, it's got to go through the formalities. You can say at any stage that this issue has arisen in negotiation, we've asked you for Section 30 order, you're not doing it. Or we think that this means this, and the Westminster think that it means something else. If you can just go to the Supreme Court to produce that as an issue, the constitutional difficulty with that is it does suck the court into what might be either an advisory or a political process. And it prompts the question that I raised before the short adjournment as an issue with the Lord Advocate's cases, is where is the principled line? Yeah. At what point can you do that? When can you do it? Under what controls? Yeah. Which the answer may or may not be that it's sufficient to say we are a court and we've got discretion.
Yes. Well, in a constitutional statute of this kind, the view might rationally have been taken that if you entrust the power exclusively to the law officers, then you can be confident that references will only be made on a responsible basis where it's in the public interest, or that's the judgment of a public interest by the relevant government. And the long stop protection is the court's ability to protect itself by declining to get involved in the exercise of its discretion in matters which, for example, would be politically too sensitive.
My Lord, you might take that view, and I addressed that before the short adjournment as well. The difficulty potentially is that you end up with some pretty unwelcome consequences from the Lord Advocate's perspective about the stage at which other law officers on the opposing side of the argument might be able to refer inchoate legislative policy ideas of the Scottish Government to this court and demand an answer or ask for an answer subject to your discretion. And of course I recognise that the court has a discretion and can control to some extent, but the point I was really making, the principal point I was making before the short adjournment, was there are limits to that, and when a court is exercising a discretion, perhaps a fortiori a discretion which it has discovered, rather than having conferred expressly upon it under the Act, it will be very concerned to do so in accordance with the consistent and faithful treatment of the structure and content of the Act. And of course, the only thing that we're really dealing with here are things or subject matter areas which are to do with draft bills, because that's the only point at which the Section 3111 problem arises. It's to do with having to make that statement. That's why we're here. So it's always linked to draft bills. And that direct link, which is what I entirely accept causes the legality issue that my Lord Lascelles was raising before the short adjournment, that only arises in relation to draft bills, and that does take one very, very close to the procedures that are set up very carefully under the Act that lead to the precise resolution. Now, of course, you will end up with some that don't get through the barrier.
Yes, I see that.
That's just a question of who takes the political and legal heat at what point under the structure of the Act.
The consequence of your submission is that if there is a disagreement, for example, over whether I don't know, the dimensions of widgets fall within reserved matters.
It matters not.
Then the Scottish Government would have to promote a bill, the Widgets Scotland Bill, and wait to see if the matter was then referred under Section 33 to this court, rather than the question whether widgets fall within reserved matters being taken to this court at a much earlier stage.
That's precisely the logic. And the Lord Advocate wouldn't have to wait for someone else to do that. Once it had reached that stage, she's one of the list of the law officers you can refer at that point. The real sting in the argument against me is to say that there will be some examples when the Lord Advocate is, or the person in charge of the bill, is unable to make the statements, as a result of which the Scottish Parliament will never get to debate widgets. And that I've sought to address in the manner that I've done. I'm sorry to reprise those submissions, but that's how we put it.
And so just taking one of your worked examples, then you refer to Section 23. And if I understand correctly, the worked example was 23, 1A and B, is that right? Or not? As a function. Or which one?
It's a parliamentary. Parliament can require
any person.
It's a power of compulsion.
Yeah, a power of compulsion. And you said that if you applied 1F.
If you then go to 23.6, you've got to next.
Yes.
So that function, where the functions of a body relate to reserved matters, that's the bit. The Parliament may not impose. So the power of the Scottish Parliament to issue that compulsion does not run in those circumstances. And so I say that fits within, if this was going to be your, well, perhaps I'll let you ask your question.
No, within the sweep all clause at the end of...
Exactly so, and not within the first part.
And not within the first part. And then you postulate that you would then have a reference by the Lord Advocate in relation to whether it did or didn't relate to a reserved matter.
Yes, in relation to that.
In relation to that.
Exactly so. And
what's wrong with that?
Well, you can have these are devolution issues that can be referred under paragraph 34. So if they fall in the tailpiece, they can be referred as devolution issues. Yeah. And so if there was an issue about whether or not the functions of the body in question related to reserved matters under 23(6), yes, that could be referred under 34. I've got no difficulty with that.
Right. Okay.
My argument is that that gives the meaning and the control, the limit to those tailpiece words. What the Lord Advocate has to do is to say, no, that goes more broadly. What that means is that you can refer the question whether I could make or I'm doubtful about making a Section 31 statement. My point is that this is a very specific reference to the sorts of examples that sit within the tailpiece of the wording. And so all of those are examples that I've given you in the clip.
So if Parliament...
They relate only to UK ministers or the Scottish Parliament?
I do, because otherwise that's the distinction that's being drawn.
Extend to the powers of the Lord Advocate?
Yeah, they don't.
So what you envisage under 23 is that Parliament requires someone to produce the documents in his custody. That person says no, because all my functions relate to reserved matters, so I'm not going to produce them.
I'm UK, I'm not Scots.
Yeah, I'm not going to produce them, and there's then a standoff between
and then there'll be a
them,
standoff, and that will be
there can
resolved.
be a reference of that issue to the...
And that would be the legitimate subject, to go back to Lord Stevens' question, that would be the legitimate subject of a reference under Para 34.
Yeah.
Why would it be a... Why can't it just be a member of the Scottish government being required to? Or why does it have to be a minister of the UK government? It's require any person. And
yes, but these are Parliament's powers. These are powers of the Scottish Parliament.
Yes.
And so it's reserving, it's saying the powers of the Scottish Parliament in one are controlled in this manner. So the focus is on whether it's the focus is on the nature of the power. It's a Scottish parliamentary power.
Yes.
It isn't a ministerial power. So the fact that the body in question isn't one thing or another doesn't really matter. What matters is that this is a parliamentary power, just like the other powers are either parliamentary powers or the powers of a UK minister.
I mean, it seems to be saying that the Scottish Parliament can't hold before it
UK bodies.
Yeah, who's exclusively UK.
Exactly so. But the point for present purposes is a parliamentary power. I don't quibble with the idea that 34 could refer. Of course it could. The question is what that tells you about the meaning.
Would it be fair to say that the implication of your argument is that it's in 1F2, when it says any other question arising by virtue of this Act about reserved matters, the words by virtue of are really meaning expressly under a provision of this Act.
My Lord, they are when you read them with being about reserved matters and you look at the contrast between F1 and F2. Yeah. I'm a bit worried that my Lord will take that as being answered by the definition of by virtue in section 126. But that is it. That is it. It's referring to that concept as specifically referred to in the Act, and we've given you examples of where that's done.
Yes, I mean the broader view is really taking the view that the Act gives rise to a lot of questions about reserved matters.
It is.
But you're saying that's too broad an approach. There are specific provisions of the legislation which require, which refer specifically to reserved matters, and that's what this provision is about.
And you have to look at what that whole phrase in context, arising by virtue of this Act about reserved matters. Yeah. You look at it in the specific context of F1 as well, which is referring to competences for obvious reason. And you look at it in the context of the inexplicability of saying, as my learned friend does, in relation to Section 31, not merely have you got the Section 33 process which follows on the time sequence that we saw, but in relation to the Section 31 power, the doubt about a Scottish statement or a statement by the person in charge of the bill about competence must include all the matters in 29.2.
Yes. Yes,
Otherwise it doesn't make any sense.
So you say the Act confers limited powers on a variety of institutions, and the first part of 1F is concerned with the limited powers of the bodies exercising devolved competence, and the latter part of 1F is concerned with other institutions whose powers are defined by reference to reserved matters.
Yes, exactly.
And how does that fit in with your submissions about paragraph 4 of Schedule 6, which is at 326? Do you say that kind of question about whether the person has to produce the documents under section 23(1) if required by Parliament, that is something that doesn't have to come here, it can go to the Court of Session?
You can under that procedure. And that again makes sense, it might be thought, because that's to do with the that's not to do with draft bills and section 33 and matters at the top of that legislative, as it were, hierarchy, which comes straight to this court. I hesitate to describe them as second-order issues, but they're issues which might benefit, as it were, from that resolution process ultimately coming here, not coming here direct as a court of original jurisdiction. That's it.
Do I discern your argument to be that Section 31 refers to legislative competence and therefore doesn't refer to reserved matters and therefore doesn't fall within paragraph 1F? Or are you accepting that Section 31 has to be read with Section 29 and it does refer to reserved matters?
My submission is that Section 31(1) does require a statement to be made about legislative competence. Legislative competence is a defined term, and it includes all of the categories in 29 sub 2, and therefore it can include reserved matters, but it covers broader things. When you get then into section or paragraph 1F, you've got the things being split out. And the only reference in the tailpiece is to reserved matters, which is one of the subcategories of competence.
Yeah. I mean, this I think, is really repeating a point that Lord Lloyd-Jones made. The consequence is that that while F2, as you say, is concerned with bodies whose powers are defined by reference to reserved matters, one body whose powers are evidently so defined is the Scottish Parliament, but it wouldn't fall within those closing words on your submission so far as its legislative functions are concerned, but it would in respect of other functions under the Act, of which the one example we found is its power to call witnesses and require the production of documents.
Yeah, that's one example. Exactly so.
So, am I understanding it correctly, then, that you say that within F there are two mutually exclusive categories?
Yes.
And you base that submission on the word other.
And on the reference solely to reserved matters in that way.
And on the reference solely to reserved matters. Is it relevant to your submission that the word other also appears right at the start of F, in the first category, the first subcategory? So any other question about whether a function is exercisable within devolved competence, is that not, and then the word other appears again, is the word other in each case not distinguishing what's gone before in A to E as opposed to the word in the second part of F distinguishing what's appeared in the first part of F?
To which I'm not sure what the answer to that is. Certainly F1 must be referring to points of distinction with what has gone before in paragraph, in particular 1C. It's a little difficult to see how 1C marries up with the first wording, i.e. F1A. If you want a philosophical teaser, you might think about that. Not sure we come up with a very good answer to that question. But whether one can go further and say, therefore, the other thing must be doing the same thing, I'm not sure.
All right.
You still use the word.
But your submission depends on them being mutually exclusive categories. Yeah.
But I thought that was more to do with the definition of devolved competence and
What, F1?
the fact that they don't cover the same material, F1 and F2.
It's in part to do with that, in large part to do with that, because devolved competence only applies to ministers in that way, Scottish executive in that way.
Well, as I understood it, the point of a question is that questions can arise by virtue of this Act about reserved matters under A to E. And F catches any other question arising by virtue of this Act about...
Well, my Lord, I can perfectly contentedly live with that. That doesn't damage my argument, I respectfully submit, because, for example, you have in A actual enacted acts of the Scottish Parliament. So once it's gone through, and you have in the bits that I referred to earlier on, proposed things in B, C and D. So I'm not sure I'd accept, if this is the purport of the question, that damages the distinction that I draw.
Well, if it's right, it would mean that arising by virtue of this Act would have a wider connotation.
Well, it's still got to be about reserved matters.
Yeah.
And if it adds to A to E, so be it. The distinction that is drawn, particularly bearing in mind that reserved matters is only referred to as a separate concept in the tail piece in F2, still have to be taken into account and given a full force and meaning and effect.
Yeah.
So even if it's intended to add to A, B, C and D and E, I'm not sure that touches the basic point I make, which is that there are two different things being dealt with in F1 and F2 for the reasons I indicated. And the only way of actually making sense of all of this is to try and identify where the Act has referred to reserved matters as an isolated concept and have a think about that.
But, sorry, just to press, I think I'm pressing on the same point. I mean, doesn't it make a difference which the comparator is for the purposes of the other that's being compared? So true it is that you've got two limbs to F, but the first limb must be comparing what is expressed there with what has gone before. And one can see, for example, at C, that could cover the same ground to an extent, but there may be an additional residue. So the comparison must, for the first other, be between A to E and whatever residue might fall within F. As I've understood the points being put to you, I just want to make sure that I've understood your answer. If one reads the words "and any other question" in the second part of F, interpreting the word "other" in the same sense as in the first part, then the contradistinction is not with the first part of F, but with A to E again, as it is for the first part.
Well, yes, and I've said, I hope fairly, I accept that. That's a perfectly coherent reading of it, because the same word is being used, which is other. But you've still got to grapple with the remainders of the concept in the provision. And it isn't illegitimate to compare F1 and F2. And even if you say, well, that gives a broader meaning to arising by virtue of this Act, because you're doing a comparison with A through E, you've still got to grapple with the incoherence on my learned friend's case, which is ultimately what this is about, which ties it back to Section 31. And what Section 31 is doing, and doubts about Section 31, at which point, if it covers that, why is reserved matters only referred to, when competences could create the very doubt that would not enable the statement to be made? So ultimately, I can live with my Lord Jones's point, which says, well, do the comparison with other, and that may lead to as it were, a slightly broader or differently focused purpose of comparison, but you've still got to grapple with the remainder of it, and in particular, you've got to grapple with what reserved matters means, referred to as an isolated concept.
that reading, if correct, of course, that reading would deprive you of the argument that there are mutually exclusive categories. But it wouldn't deprive you of the alternative argument based upon the second limb being limited to reserved matters.
My lord, yes, I think that's fair. I think that's fair as a matter of logic.
But just on the second limb then, I can see that you've identified for us certain points in the Scotland Act where something doesn't fall within devolved competence, so isn't swept up in the first limb, and therefore, if you've got a sweep-up provision, you need to capture it in the second limb. And I can see that there are some functions like that which are where the words are expressly used, talking about the boundary being reserved matters. But in a sense, it might be said that the question of introduction of the bill also could be read as falling within that category. It's true the express language isn't used there, but nor is it something which falls within something which is exercisable within devolved competence, because it's a function of a parliamentarian, if you like, in the operation of the proceedings in the Scottish Parliament. So if the relevant divide is between things which are the residue within the devolved competence category and things which are in the residue of the about reserved matters category, could it not be said, unless you pin that last category to the specific language each time it's used, that in fact what we're talking about does fall within that latter category?
Well, I say you have to pin it to the exact language. Right. That's the only coherent explanation for why that latter the last two words are used.
Okay.
And particularly when you get to section 31, where the statement that is required to be made is a statement about competence.
Because you say this shouldn't be swept up in either F1 or F2 because it's dealt with in section 33 exclusively.
Yes, and in fairness, and I do take the point of it that Lloyd Jones is putting to me, which is if you can view these as being, as it were, referring to a comparator in the earlier part of paragraph 1, and to some extent, I say so be it to that, and you've still got to do reserved matters, you've still got to have a think about that, why are they there? But even if that is the prime point of comparison, you've still got a comparison that is inherent within F itself. And that may be of some interest when you're trying to work out what the right interpretation is. I accept that none of this is easy. but I do submit that it is quite a stretch and quite a cut across to say the consequence of this is that whenever a Scottish minister or a person presenting a bill has a bit of doubt about whether something is within competence, they can simply turn around and say, subject only to the discretion of the Supreme Court to control its own procedure. I can avoid section 33 and I can go and ask the Supreme Court for advice about whether or not, if I wanted to introduce this legislation, it would be good, bad or indifferent. They could turn up and say, I'm thinking of doing it in this way, but I might want to do it in that way. Which do you reckon is better? There's got to be some control on it, and that involves, to some extent, I quite understand why we've gone into the interstices of the language and how the comparators might work and all the rest of it, but to some extent it involves a stand-back exercise to see what the Act is actually trying to do, and constitutionally, what controls it's actually trying to impose before this court's original jurisdiction is engaged. Tempted to say rien ne vint plus, but I'm grateful.
Yes.
And
thank you very much, Sir James.
For submitting in that time.
Yes, Lord Advocate.
Yes, thank you, my lords, my lady. As a preliminary matter, I can confirm to the court that I've provided and to the Advocate General's team a note setting out the role of the Lord Advocate and other law officers at stage 3 of the passage on legislation in the Scottish Parliament. So I think that was something that we touched on yesterday. And I've also provided section 67, section 63 and schedule 7 to the court and to the Advocate General's team, and the note that I was asked to provide in relation to the procedure in relation to private members' bills. So,
and the first of those items was essentially a description of how bills pass through the Parliament.
That's correct, my Lord.
I'm not sure I've got that.
Well, if,
I mean,
well,
we got a clip this morning with, let me see, we had 3 documents in it. One was Schedule 7. One was Section 63, and the third was the note on challenges to members' bills.
yes, very well. I think that what is missing from that then is the issue around stage 3 passage of the legislation in the Scottish Parliament. That can be, that's just been missed off the list of things that you've been given, my Lord.
Is that note on challenges to members' bills in the Scottish Parliament?
Yeah. Is it the same thing, a different? So it's the same thing, it's a different label. Yeah.
Oh.
Well,
It's in the folder, in the bundle, in the...
Do from the bottom.
so it's just, there's the same thing in this one document. That's perhaps.
Yes, I've got note on challenges to members' bills in the Scottish Parliament,
Yes.
which appeared as the penultimate item in the folder, so far as I could see.
I think that, so that's everything, I think.
Oh, I see. It's page 4 of that document. It's simply the relevant rule in the standing orders.
Yes, that's so much.
Right.
So I wish to begin my response to Sir James Eadie's submission about the bringing of this reference and the consequences for this court. Should it accept my submissions that the court has jurisdiction to determine the reference. First, I want to emphasise what I've said in the reference in my case and in my oral submissions, that this reference has been brought responsibly and after careful consideration as to whether it was appropriate to do so in terms of paragraph 34 of Schedule 1 to the Scotland Act. Second, as I hope would be obvious to this court, the reference has been brought not because the issue is trivial or one that's been raised on a whim or willy-nilly, I suppose, is one of the phrases that was used yesterday, but as noted by the President, that it is a matter of the utmost constitutional importance. Thirdly, Sir James made submissions that were to the effect that if this court were to accept jurisdiction in this reference, there's a prospect of that opening the floodgates. I simply observe that the power to make a reference is one that is conferred on law officers who can be assumed to exercise the function responsibly. I also observe that the court may have regard to the reality of the situation. And the reality here is that I have used the power to make this reference as Lord Advocate, and it is the first reference since the beginning of devolution. So how one might test the floodgates argument might lie in the reality of the situation. This is the first such reference in the history of devolution. Finally, on the practicalities of matters, there was some suggestion and discussion that because a Section 31 statement is made by a minister, the role of the Lord Advocate is somewhat remote to that of the minister making the statement, and that the minister in charge of the bill might obtain their legal advice from a source other than the law officers. I have two things to say about that. Firstly, as a matter of practicality, it is wholly unrealistic. It would be both unlikely and undesirable for ministers in the Scottish Government to seek legal advice on issues of competence in circumstances in which the law officers are the principal legal advisors to the Scottish Government and indeed are ministers in that government. Secondly, and in any event, the answer lies in the ordinary principles of public law. The Minister must act rationally and in good faith, and must inform themselves by taking legal advice. Next, in relation to Sir James's reference to this court in relation to several judicial review claims that have emphasised that the fact that the courts will not give advisory rulings before a concrete legal issue has been crystallised, he submitted that this was the backdrop against which Parliament legislated in terms of Section 33. And I would make a number of points in response to that. Firstly, one should treat with caution the submission that Parliament has legislated against the backdrop, as Sir James put it, of the cases he cited to this court, or any specific principles of the common law, since the cases cited by Sir James all post-date the Act. Secondly, it is clear that in any event that Parliament intended to create an unusual mechanism for obtaining judicial determinations on issues arising under the Scotland Act that is very different from ordinary legal proceedings. In my submission, there's no reason to accept Sir James's submission that Parliament thereby intended to create a narrow, heavily circumscribed or restricted jurisdiction. On the contrary, paragraph 1F of Schedule 6, read with paragraph 34 of Schedule 6, demonstrates an intention on the part of Parliament to create a jurisdiction for law officers to refer questions to this court about reserved matters of the broadest amplitude. The only limitation on that power is that the issue has not arisen in legal proceedings. This is the express limitation within paragraph 34. Had Parliament wanted to create a more circumscribed power, it could have done so. On the contrary, it was the intention to create a sweep-up provision that ensured no issues about reserved matters could arise that were not in principle capable of being referred by a law officer to this court.
Why not sweep up other aspects of legal competence?
Simply by the fact that the issues in relation to other legal competence haven't been swept up doesn't mean to say that issues about reserved matters shouldn't be. And it was really, one can only imagine or try to understand what the legislature were about. But the import of reserved matters was one that was something law officers of the day had to have in mind at the highest level in relation to all of the functions that they provide in advice to the Scottish Government. So reserved matters was a key issue for the law officers of the day in this particular case, and it's of the highest importance when one has regard to the operation of the Scotland Act. So the fact that there was a distinction doesn't mean to say that means that the reserved matters aren't available for consideration by this court. This distinction was made. One can only try and work out why that is, but that doesn't mean to say that the provisions of Schedule 6, paragraph 1F, don't entitle any other question arising by virtue of the Act about reserved matters for being referred under Schedule 6, paragraph 34. And Schedule 6, paragraph 1, is very broad in its terms, and it is broad in nature. And the first point to think about is how one looks at it. It's wrong to use simply the prism of paragraph 34 under Schedule 6 to try and understand what the purpose and the parameters are of paragraph 1 to Schedule 6. It's very broad in nature, and the breadth of it, in terms of what's set down in paragraph 1A through to E, informs ultimately the breadth of the provision of paragraph 1F. So if we have a look again at electronic folder page number 322, and we look again at Schedule 6, paragraph 1, we can see the definition of the devolution issue there. And in relation to 1A, it means a question whether an act of the Scottish Parliament or any provision of an act of the Scottish Parliament is within the legislative competence of the Parliament. It also relates to a question whether any function, being a function which any person has purported or is purporting to exercise, is a function of the Scottish ministers, the First Minister or the Lord Advocate. It also covers a question whether the purported or purported exercise of a function by a member of the Scottish Government is or would be within devolved competence. It also relates to a question whether a purported or purported exercise of a function by a member of the Scottish Parliament, the Scottish Government, is or would be incompatible with any of the Convention rights. It covers a question whether a failure to act by a member of the Scottish Government is incompatible with any Convention rights. And in relation to F, or any other question about whether a function is exercisable within devolved competence, or in or regards Scotland, any other question arising by virtue of this Act about reserved matters. Schedule 6, paragraph 1F is not limited to any extent, particularly it's in the context of what we're dealing with here. It's certainly not limited or circumscribed by to any effect by the reference to any other sections of the Scotland Act. And it is broad in its amplitude in order to provide the sort of innovative procedures that the legislature had in mind when this Act was implemented. And I've touched on the rationale and the reasoning behind the Scotland Act in my opening remarks here. So to look too narrowly at Schedule 6, paragraph 1F, particularly in relation to the reference to and any other question arising by virtue of this Act about reserved matters, would be to restrict the amplitude of Schedule 6, paragraph 1F in a way that Parliament simply didn't intend. There are also, in my respectful submission, some important matters to deal with in relation to the explanatory note, and also in relation to the way in which the Act operates in practice in the courts throughout Scotland when we're dealing with devolution issues and reserved matters under the Act. Can I turn firstly to the explanatory note, which Sir James drew this court's attention to? And the explanatory note is at page 379 of the electronic folder. It is important to have regard to the full content of that explanatory note so far as it relates to subparagraph F, Schedule 6, paragraph 1, and the question of what is or not a devolution issue. So it says this: subparagraph F, any other question about whether a function is exercisable within devolved competence or in or as regards Scotland, and any other question arising by virtue of the Scotland Act about reserved matters. So the opening phrase is consistent with what explaining about the way in which Schedule 6, paragraph 1F operates. So it's entirely consistent with that. It then says this: the question swept up into the subparagraph can arise in various circumstances. There's no delimitation there or listing of where these particular issues might arise under the Act. It goes on to say this: for example, there could be a question about whether Her Majesty is making an order in council within devolved competence, see note on section 188, or whether a function is exercisable in or regard Scotland, so that it may transfer an order under section 63, and we know section 63 relates to the transfer of further functions to Scottish ministers, or whether a public body is a Scottish public authority whose functions are exercisable only in or regard Scotland. See definition in section 126 on whether the functions of a body relate to reserved matter. See section 1263. So I say that the explanatory note referred to by Sir James suggests that a reference might be made in relation to the making of an order under section 63. Section 63 is about the transfer of executive functions. So the explanatory note might equally have referred to a section 30 order. A section 30 order can be made to change Schedule 5 in relation to reserved matters. So there's no reason why it couldn't refer the question whether section 30 order is required to establish whether the matter is or is not already reserved. So if a section 30 order...
Sorry, what would be the point of that? I mean, if one's looking at a section 30...
So if one's looking at a section 30 order...
Isn't that the order that distributes matters between the UK government and the Scottish government by potentially amending Schedule 5?
That's right, that's right. And that, the section 30 order was obtained in order to permit, as was at that stage seen as the gold standard of legality in relation to the first referendum.
Right.
Yeah.
But why would you need, if there is a proposal to legislate, to make it clear that some matter either is or isn't a reserved matter? I can't see what would be the point in having litigation about that.
Well, I think the question is whether or not the issue is a reserved matter. And the question that would be before, for example, those involved in determining whether or not to make a Section 63 order or to make a Section 30 order, the question would be, is it required to establish whether the matter is or not already reserved? So you would...
Why do you need to know that? I mean, you're going to make an order which puts it beyond any doubt.
I understand that, but you're informing yourself as to whether or not the order is necessary. That's the point. So you might... The point is, these orders are required in order to ensure that a function that is reserved is passed over to a Scottish minister. So that would be a Section 63 order. Or you would need the order under Section 30 in relation to, for example, an alteration to Schedule 5 to ensure that an act that would be considered to be without competence in relation to a reserved matter would be necessary. The question might be asked, do we need that? Is it a reserved matter? So if you can refer a reserved matter over the competence or necessity of a Section 63 or Section 30 order, it doesn't make any sense then when you look at the terms of section paragraph 1F that you couldn't refer the same sort of issue, an equivalent issue, under Part 2 of 1F, which is any other issue arising by virtue of the Act, which is what we're proposing. We are pushing forward in terms of this reference.
I wonder if I might give or put to you an example which might illustrate the point you're making. When the Section 30 order was made to enable the 2014 referendum to take place, it was made under subsection 2 of Section 30, which is the modification of Schedule 5.
That's right.
So as to to modify Schedule 5, and so and it did that by inserting a new heading into Schedule 5, which covered the 2014 referendum.
Yes.
Now, we see how the current political issue has generated these proceedings.
Yes.
An alternative form of proceedings might have been to well, I wonder. But what's something in my mind is if one might have challenged the UK government's insistence that a Section 30 order was necessary as being based on an error of law and sought to judicially review it. Now, the issue in those judicial review proceedings would have been whether the holding of a referendum was a reserved matter.
Yes.
And I imagine on your argument, you would say that would have been a matter which could be raised in proceedings under paragraph 4 or referred to this court under paragraph 34.
Yes, that's so. That's exactly my point, is that if one looks at the explanatory note and understands what that's saying, then exactly the point my Lord makes is that, and so if one then applies that reasoning to why we're here and why I say it falls under paragraph 1A, one can see the logic in the position that I'm adopting before the court. So the explanatory note suggests that the law officers could have referred the 2013 order to ask essentially the same question that we are asking. So it doesn't, Sir James's whole analysis falls apart if one approaches it in the way that you suggest. So the next point that I wanted to raise with the court relates to an issue aptly described by the President in this case as when he described this court as having a constitutional jurisdiction. We agree with this characterisation, and in my speaking note on jurisdiction and discretion at paragraph 39, I referred on this point to the case reference secession of Quebec, which I referred to at paragraph 39 of my note on jurisdiction, and at that point I only limited what I had to say to paragraph 25 in my note. But I think, in my respectful submission, the point is worth referring in a little more detail, and so I'd like to refer the court to the wider passage of that judgment from paragraph 24 onwards, and because it is relevant ultimately to some of the issues that this court's dealing with. So might I refer to the reference secession of Quebec case, and it's in the supplementary bundle of authorities which was lodged by the SNP intervention, and the paragraphs that I would like to look at begin at page 818 of the electronic folder and go through to page 820. So the paragraph begins paragraph 24 on page 818, and I wish to read from there through to the end of paragraph 28.
I just missed the paragraph number.
So I'm reading from paragraph 24 through to the end of paragraph 28.
Thank you.
Now, we haven't looked at this until now, so if there are issues arising in relation to it,
yes,
on which Sir James needs to reply, I'll give him that opportunity.
Yes, thank you, Lord. So under the heading of justiciability, the court said it is submitted that even if the court has jurisdiction over the questions referred, the questions themselves are not justiciable. Three main arguments are raised in this regard. The questions are not justiciable because they are too theoretical or speculative. the questions are not justiciable because they are political in nature. The questions are not yet ripe for judicial consideration. In the context of a reference, the court, rather than acting in its traditional adjudicative function, is acting in an advisory capacity. The very fact that the court may be asked hypothetical questions in a reference, such as the constitutionality of proposed legislation, engages the court in an exercise it would never entertain in the context of litigation. No matter how closely the procedure on a reference may mirror the litigation process, a reference doesn't engage the court in a disposition of rights. For the same reason, the court may deal on a reference with issues that might otherwise be considered not yet ripe for decision. Though a reference differs from the court's usual adjudicative function, the court should not, even in the context of a reference, entertain questions that would be inappropriate to answer. However, given the very nature of a reference, the question of the appropriateness of answering a question should not focus on whether the dispute is formally adversarial or whether it disposes of cognizable rights. Rather, it should consider whether the dispute is appropriately addressed by the court of law. As we stated in Reference Re Canada Assistance Plan, while there may be many reasons why a question is non-justiciable, in this appeal, the Attorney General of Canada submitted that to answer the questions would draw the court into a political controversy and involve it in the legislative process. In exercising its discretion whether to determine a matter that is alleged to be non-justiciable, the court's primary concern is to retain its proper role within the constitutional framework of our democratic form of government. In considering its appropriate role, the court must determine whether the question is purely political in nature and should therefore be determined in another forum, or whether it has a sufficient legal component to warrant the intervention of the judicial branch. Thus, the circumstances in which the court may decline to answer a reference question on the basis of non-justiciability include, if to do so would take the court beyond its own assessment of its proper role in the constitutional framework or of our democratic form of government, or if the court could not give an answer that lies within its area of expertise, the interpretation of law. As to the proper role of the court, it is important to underline, contrary to the submission of the amicus curiae, that the questions posed in this reference do not ask the court to usurp any democratic decision that the people of Quebec may be called upon to make. The questions posed by the Governor and Council, as we interpret them, are strictly limited to aspects of the legal framework in which that democratic decision is to be taken. The attempted analogy with the US political questions doctrine therefore has no application. The legal framework having been clarified, it will be for the population of the Quebec, acting through the political process, to decide whether or not to pursue secession. As will be seen, the legal framework involves the rights and obligations of Canadians who live outside the province of Quebec, as well as those who live within Quebec. As to the legal nature of the questions posed, if the court is of the opinion that it's being asked a question with a significant extra legal component, it may interpret the question so as to answer only its legal aspects. If that is not possible, the court may decline to answer the question. In the present reference, the question may be clearly interpreted as directed to legal issues. So interpreted, the court is in a position to answer them. So I don't need to make reference to any other part of that. So I'm really drawing the distinction between a litigation process that the courts are so familiar with, as opposed to a reference process, and the constitutional role of the court in that respect, and one in which we say is directly analogous to the reference procedure that we are seeking the court's answer to in this particular case. So it's a different function, but we do raise legitimate, important, and constitutionally crucially important questions for not only Scotland, but for the whole of the United Kingdom. And it's entirely appropriate that this court, the Supreme Court of this country, deals with this issue. And that's really the thrust of what I would wish to take from this case, and that's the sole reference that I make to this particular case in this reference before this court. The final issue that I'd wish to touch on in my response is the point about the issue of law in this case. And I only seek to emphasise this, that the issue of law referred to this court has crystallised because it is an issue that I and a minister seeking to introduce the draft bill have to ask and answer now. As I made clear in the reference to this court, and it can be seen at electronic page 5, the whole reason for this reference was the First Minister of Scotland recognised that all it should be done in Scotland is a legally piece of legislation, a legally sound piece of legislation is introduced to the Scottish Parliament. That's all that's being asked for guidance on that particular issue. And as I said in paragraph 2 on electronic folder page number 5, the First Minister recognised that the question of whether a bill providing for an advisory referendum on independence related to a reserved matter was contested. It was she who asked the Lord Advocate, the law officer of the country, to consider making a reference under paragraph 34 of Schedule 6. So it was on request of the Minister that the references was considered by me, independently of government, in accordance with the retained function that I've been given under the Scotland Act. And it was after having given the matter detailed consideration that I decided to make this reference. And
are those points going to our discretion, or are they an answer to Sir James' points about, well, what is the trigger? What is the starting moment from which, as you just put it, the power is to make this reference is crystallised?
Right. So I think it goes to the second point that my lady made. And I think Sir James was suggesting that things were to be done willy-nilly, that just when something popped into somebody's head, that they would make a reference. And it's to belittle, it's to minimise the enormity of the issue that's being brought to this court. And it's to determine, to show that the issue is not academic. It's crystallised. It's a real issue that has been a festering issue since the days of devolution. And in this context, we've taken the correct constitutional role in bringing this matter for a reference. And Sir James's characterisation of what is involved here is unfair. That's the point I'm making. It's just not right that he should say what he said about why we're here. It's so unfair. And it's reflected in everything that we've put forward in our case. And the trigger is the First Minister of Scotland, because she recognised the importance of the issue and the importance of making sure that everything's done legally, asked that I, as law officer of the day, took the consideration as to whether or not a reference was appropriate. Now, it may be that a different law officer would take a different approach on a different day. And I don't pretend that I'll only ever be the only law officer from now until the end of time. Of course, I'm merely a custodian of the office for a very short period of time in history. But what we know is that in the history of cases that come before this court, lawyers win cases they think they're going to lose, and lose cases they think they're going to win. And when they're very clearly, carefully balanced legal arguments that really can't allow a minister in charge of a bill to make the positive statement that's necessary in this case, the constitutionally right thing to do for the law officer of the day is to bring this issue to the court, and that's what's been done. And so I wouldn't wish to make any other response.
Well, thank you very much, Lord Advocate. Sir James, anything arising from the Quebec case? No. Well, we're most grateful to Council and no doubt those sitting alongside them and behind them for the submissions that we've received. As I said at the outset, we'll require time to consider what we've heard and what we'll be reading, but we appreciate the importance of this, and we'll let you have our judgment as soon as we can. The court will adjourn.